All right, good morning, council. Hope y'all are all doing well. We may have a long day today. We have a lot of material to cover this morning. We'll take breaks as needed, and I will let y'all know. I know that some of you emailed me several things even as late as 10:30 or 11 last night. I will confess I have not read all of that yet, not the things that came in last night, but I have at least had an opportunity to look through everything that we have set today. I have read most of the motions, may need time to look at some case law, but I think we are ready to go. Let me first ask, and I'll go ahead and Cindy get us on the record. This is Coke County cause number CV1604622, Carol and Peggy Lee versus Memorial Production Operating and others. We are conducting this hearing today in anticipation of an October 18th jury trial. I am presiding from my open Tom Green County District Courtroom. I will tell y'all, I apologize. This is not a YouTube effect. It is hot. Our air conditioning may not be working in my courthouse today. And so I have a fan on my bench. I'm not trying to do the glamour girl look with air blowing though, just trying to survive. Our chiller died several months ago and it won't be replaced until November. So periodically some days are better than others. But anyway, if you think, what is she doing? That's what's going on. But I am in my open Tom Green County District Courtroom to allow public to observe. I also have gone ahead and put us live on YouTube. There are, I think I mentioned on Monday, there were a couple of local high school students who are interested in going to law school. And this is a case, environmental issues and ranching issues are things that may be of interest to them. And so I have us live on YouTube so that if they want to log in and watch at any point, they can. And so y'all don't be concerned about that. All right. Is there anything that y'all can tell me this morning that we do not need to spend time on?
Your Honor, for the lead plaintiffs, we spent yesterday working cooperatively on trying to resolve limine issues. And the mistake we made was probably making me the clearinghouse. But other than that, we made a lot of progress in that I've spoken with each defendant's counsel, and each defendant's counsel has talked with me. And we have all of the consents that run between them and me. And so we need to consolidate those, make them for the whole group, and then take up the remaining ones. But generally, there's a good consensus on them. And so I would suggest if you give us a little more time on that, we'll even make more progress, and then we'll boil it down to fewer of the ones that are being contested.
Okay, excellent. And then obviously we have the expert motions on experts today. And I know we've had some objections to some exhibits. Do y'all have a set of exhibits that y'all have determined, even if you may not have them all numbered yet? Have y'all made progress on determining some exhibits that everyone can agree to be pre-admitted?
Your Honor, my paralegal went through and spent the better part of Tuesday compiling a list of all exhibits that are in common, and then exhibits that are not in common, and we circulated that, and I think that's going to make some headway. But we have some issues now that are concerning to me regarding Jason Foster's deposition and the change or abandoning some of his liability theories that may cause Granville to have to object to other exhibits. I don't know if the court wants to go down to that rabbit hole yet, but other than that, I don't know. It's problematic for Granville. It may not be problematic for anybody else.
Okay. What we may do is we may address that. What I thought I would do is, while we're all fresh, we would start with the simply because I've had them longest, the defendant's motions to limit or strike testimony on Mr. Farley and on Mr. Foster. And that may be, when we address Mr. Foster, that may be the time to talk about other exhibit issues that we have as we focus on kind of on each witness.
Well, Your Honor, respectfully on that point Mr. Terrell just raised, we of course saw his motion that came in last night, but just candidly, I don't think we're prepared to take up those issues. That's the first we've heard of the whole dynamic, and I'm certain we'd want to talk with Mr. Terrell about it, because I expect we'd reach agreement on some portion of that, or at least better understand it.
Okay, that is fine. Are we still needing to take up the motion to strike or exclude Mr. Foster? Just not the second step of the issues with Mr. Foster. Is that what I'm hearing, counsel?
Your Honor, I think that's right. However, with their withdrawing some of the theories, I don't know really what his theory of liability is going to be. I don't know. We may have to redepose Mr. Foster, or he may have to issue another opinion after although when we took his deposition, he abrogated a lot of things and agreed with us on a lot of issues raising regarding the double E Packer and who might have installed it, which seems to be the plaintiff's theory in the case. So now that he's saying or withdrawing, let me just read it to you. It says, there consequently is no basis in the record to support a conclusion or inference C.C. Forbes participated in installation of the illegal E.E. Packer. That has sweeping consequences regarding his testimony. I believe at one point he testified when I deposed him that he believed that Baltazar was not telling the truth, Mr. Baltazar with C.C. Forbes. And he further said that he believed that Baltazar and C.C. Forbes were hiding a problem lower down at the Packer, or maybe didn't even install the Packer. Then it goes and leapfrogs to the next section about whether or not then C.C. Forbes participated in faking an H5 test. So I think when you wind this all back up and start over that C.C. Forbes didn't participate, then Granfield couldn't have participated because they were the workover rig stayed there until the 21st of December, and then the H5 test took place. So what I'm rambling about is that if there wasn't an E.E. Packer in the hole by C.C. Forbes, then there wasn't anything to mask any test of the H5, and it just keeps going from there. His opinions then would be he's critical of all operators because they allowed this E.E. Packer willingly to continue to mask pressure either on the injection string or the annulus, the backside, which ultimately caused maybe a deterioration in the mechanical aspects of the well, which caused the failure. So if this makes sense, by abandoning that, Colonel Foster, it really has far and sweeping issues for all defendants, primarily Granfield, I think.
Your Honor, if I may, I'm handling Mr. Foster's expert challenge today. And I reiterate Mr. Addison's comment that I think it's frankly premature for Mr. Terrell to be presenting this issue since they only filed the document last night. But I do want to clarify one matter. I'm sure Mr. Terrell just made a good faith effort to characterize Colonel Foster's deposition testimony, but he is mistaken. Colonel Foster clearly testified that it is no longer his opinion, as it once was for him, as well as several defendants, that C.C. Forbes on December 20th installed the double E Packer. He did not, in his deposition, which Granfield has been aware of since Granfield deposed Mr. Foster, convey a belief that C.C. Forbes installed the Packer. Now, Mr. Terrell is making a logical leap. He is suggesting that because it is no longer the belief of anyone that C.C. Forbes did it, that it necessarily follows that somehow exonerates Granfield. It does not. In an appropriate context, we will put on evidentiary presentation, which establishes why Granfield is the person who is responsible for the installation of the Packer. And I will just note that up until an attempt by their own expert very recently to shift his theory, and that's a reference to Mr. Jeffrey Hughes. Jeffrey Hughes had identified Granfield without the involvement of CC Forbes as being the party who installed the double E Packer. In fact, Ivory now has filed a motion to strike Mr. Hughes' attempt to change his expert opinion to shift responsibility from Granfield to Ivory. So the notion that there are sweeping, unanticipated consequences of what Mr. Foster testified to in his deposition several months ago, we could not disagree more. But the takeaway point that I want to leave is that it's frankly premature to ask the court to try to digest or tackle these issues with less than 24 hours notice.
Thank you. And let me make it clear, what I was really have been trying to get at is we've got a lot to cover today. Where do we start? So, all right. And yes, I have not had an opportunity to review the motion that was filed by Granfield last night either. And so, you know, I have set my day aside. I have a visiting judge covering my criminal docket for me today so that I can give as much time as y'all need on this case. And what I'd like to do is let's go ahead, since it sounds like y'all are making progress on motion in limine and are still working to narrow the issues that might be contested. We won't work on that, at least not this morning. We might circle back later this afternoon. We'll just kind of see how today goes. But then also on the exhibit list, I'm glad to hear that someone's taken the lead on determining what exhibits may be exhibits that everyone wants to use and that y'all are making progress on that. So let's go ahead and jump in on the motion that I intended to take first would be the motion, defendant's motion to exclude or limit as to Chris Farley. And let me make sure that I have everything. Has Ivory joined in that motion? I do have Memorial's motion with regard to Chris Farley, and I have Granfield's motion. I have a suspicion that Ivory has joined on that motion as well, but I cannot say with certainty. Ms. Oscarson.
Yes, Your Honor. Ivory filed a motion to adopt both the motions regarding Farley and Foster on August 27th.
Okay, all right. Obviously, the rules will allow you to do so, and so we will treat these as defendants plural motions to exclude. Now let's see, I know Mr. Brill, you have some specific things that you mentioned, but let me go ahead. I know y'all are adopting a large part of Granfield, so Mr. Terrell, let me turn to you to take the lead on arguing the motion pertaining to Chris Farley, please.
All right, Your Honor, if it please the court. I think my argument is very simple and it really is not detailed at all. You know, Mr. Farley is a ranch management expert, and the defendants, or at least Granfield defendant, primarily objects that Mr. Farley in his report and his deposition testified that since the groundwater was contaminated due to the breakout, resulted, and I'll quote this, the death of the Cedar Mountain Ranch. And his opinion is that he viewed a scalded area where the breakout has impacted about 30 to 60 acres. But primarily, I object to Mr. Farley using the term that the ranch is dead. A ranch can't die. That's not a scientific term. He's not provided any basis whatsoever to support that a ranch can die. But the implication is very prejudicial to all defendants that a ranch could die, and it would be, it's obviously in this trial going to be a matter of some degree of dispute about what could have been done by the Lees and what hasn't been done by the Lees at their discretion. So that is the primary issue that Granfield has regarding Mr. Farley's testimony. Now, I certainly don't object to a ranch management talking about his experience with cattle and what they like and they don't like. Mr. Farley says and he makes this assumption that because of high levels of chlorides in stock ponds, the cattle don't like to drink that, and therefore they're not going to thrive in this environment. Now, he doesn't do any testing other than the microbe testing in the scalding area for plant life. But regarding that testimony, he's making a conclusion based upon what the Lees have told him, that they are not using the ranch because there's no real reason, no scientific reason, other than Farley says that he knows that if the water doesn't taste good, then the cattle won't drink it. He wouldn't acknowledge that there are other stock ponds on the ranch that the cattle could use, but he simply indicates they don't want to use that because it's too far away or something like that. So that's maybe a secondary objection that we have to Farley regarding his speculation about what cattle do and think and what they might like or not like. He doesn't provide any basis for that at all, and certainly not any basis. His implication is that also in his testimony that he was told that some cattle died, and I guess the assumption would be that it had something to do with either oil field operations or the spill, which was not connected by Mr. Farley at all. And really, that's all I have, Your Honor. The other defendants may have more detail about that, but those basic 2 or 3 things on Farley's deposition, but primarily his categorization that the ranch died.
Let me ask, because I did review the excerpts from Mr. Farley's deposition, which were attached to the motion. And in one spot, I know you mentioned he says it died. It seems to me that he refers to that, I can't remember if it's 30 to 60 acres as scalded land. Is there an objection? If he's not able to say that the ranch died, it seems to me that it certainly would be reasonable for him to be able to talk about that portion of land being scalded, and any difficulty in, I think he was testifying to certain grasses that might grow there, and whether or not those grasses are grasses that are good for cattle or not, that would fall within the scope of a ranch management or range management person to testify to. So you don't have any objection to that aspect. Am I hearing you correctly?
No, Your Honor. He did testing, and he can testify about that. I'm sure. I mean, it's clear about that. We don't have any problem with that.
All right. So as I listen to you, what I'm hearing is that your objection is that he not be able to give an opinion that the ranch as a whole, which I believe I saw is around 1,600 acres. Is that right? Between 1,000 and 2,000 acres, that the ranch as a whole is dead. That's one objection. The second is that he's not qualified to give an opinion as to the causation of cattle dying or being blind or having this I think stumbles. And the third is an objection to him testifying that the cattle would not drink the water and because of the odor or of the taste. Is that correct?
Yes, and the cause and effect of why the Lees haven't put the cattle back on there is more of their preference rather than some scientific reason that the cattle wouldn't drink out of the stock pond.
All right. Let me go to Ms. Oscarson. Do you have anything you wish to add or simply adopt the argument of Mr. Terrell?
Ivory will just adopt the argument of Mr. Terrell. He set forth that very well.
Right. Thank you. All right. Mr. Brill.
Yes, Your Honor. Thank you. Initially, we also adopt in our motion the arguments presented by Granfield in their motion and stand with those today. The one additional aspect that we had in terms of a more of a motion to limit Mr. Farley at trial than to strike anything that he has said is that in talking about the death of the ranch, he had some criticism of the work that ETech, the company that Memorial has retained and hired to do the remediation, and that is continuing to do the remediation even to this day, was in his response to some of Ms. Oscarson's questions, was starting to seem critical of what ETech had done out there. And so when I had the opportunity to examine him, I asked, noted that he had not had any criticisms of any of the work and remediation efforts, success or not, of ETech. At the time he authored his report in 2018, he acknowledged that. Whereas Mr. Gobb, the plaintiff's hydrology groundwater expert, had issued 3 supplemental reports. Mr. Farley had not issued a supplemental report prior to his deposition, indicated he wasn't going to issue any additional report subsequent to his deposition, had no opinions in his deposition about the performance of ETech or what they had done or their success of their work out at remediation. And so since ETech, as a company performing the work for Memorial, is so closely tied with Memorial, we have filed a motion to limit any ability of Mr. Farley to speak to the work that's been done by ETech. And I note in plaintiff's response filed last night that they say that, you know, this is a straw man motion on my part. The fact of the matter is we've had a lot of experts. Mr. Gobb, in each of his supplemental reports, has a lot of criticisms of ETech, and we went through those. We were able to go through those in his deposition. Mr. Farley, silent on ETech in his 2018 report, even though he had ETech materials to review, silent on ETech between the time of his August 8, 2018 report and his deposition, which was taken, I think, on August the 6th of this year. And so we think he ought to be limited and not allowed to offer opinions as to ETech.
All right. Anything else from the defendants before I turn to the plaintiffs?
Can I respond just quickly, Your Honor? The specific opinion that Mr. Farley elicited when I was questioning him, and I'm sure that Mr. Brill will correct me if I get this not exactly right, but my understanding was that Mr. Farley testified that ETech, in some of their remediation work, buried the topsoil. And the testing that he did showed that there was not organic material at the top, at the ground level anymore. It had been buried. So that part of the problem with that 30 to 60 acres of scalded land was not due to chemical contamination, but was due to the way that the remediation was performed. And so I do think that that particular opinion is in his scope of work. And Ivory would like to elicit that if the court will allow it.
All right, let me turn to plaintiff's counsel. Mr. Knott or Mr. Addison?
I'll be handling this, Your Honor. I noticed that the share screen is not activated.
Thank you. I apologize. Let me get that on. All right, now it should be on. Thank you for reminding me.
And may it please the court, I think that I'll take up these issues in reverse order, if it's okay, Your Honor, starting with Memorial's motion to challenge with respect to quote unquote criticisms. And I frankly am appreciative of what Ms. Oscarson just articulated, because she's exactly right. Mr. Farley, in his initial report, which I'll share screen here in just a moment, talked about a very narrow, if you will, interrelationship between the nature of the quote unquote remediation work that ETech did and the practical implications that the nature of that work had with respect to the disruption of the natural organic quality of the topsoil. But that is a factual observation regarding the status quo based upon what Memorial did. This is not an attempt on behalf of Mr. Farley to do, Mr. Brill is absolutely correct, what Mr. Gobb, our environmental expert, is going to do. He has plenty, generous criticisms of the choices that Memorial made with respect to how they prosecuted the purported cleanup remediation of the Cedar Mountain Ranch. And one example of that, Your Honor, Ms. Oscarson just made reference to it. What Memorial represented initially to the Texas Railroad Commission in a regulatory context was that they were going to excavate this approximately 30 to 50 acres where the toxic fluid had broke out its surface and basically created lakes and rivers worth of toxic material that saturated the ground. That ground area to this day, 30 to 50 days, 7 years, I believe, if my math is right, removed from the contamination, is literally dead. And I'll come back to that in a moment. It is scalded. Nothing has grown in that area for 7 or so years, whereas there are other areas on the property where we have seen growth consistent with what historically one would have expected. And the reason that has happened, Your Honor, is because although Memorial represented that it was going to excavate the contaminated soil, take that soil off-site, then bring in clean soil and replant it in that approximately 30 to 50 acre area, what Memorial instead decided to do, Your Honor, was to take that contaminated soil and just mix it with clean soil and put it right back from where it came from. So he talks about that, Mr. Farley, in a factual way, but he only does so in relationship to his concern as a ranch management professional and how the compromised condition of that soil prevents the growth of grasses that are essential for the type of cow-calf weaning operation that was being operated at the Cedar Mountain Ranch. So with all due respect, I do think it's a straw man to try to couch what Mr. Farley is going to do, what Ms. Oscarson appropriately questioned Mr. Farley about what he was going to do, what he disclosed in his expert report, and I'm going to share screen that for the court's benefit. Do you have, Your Honor, our response to Granfield and Memorial's expert?
I believe I do. Give me just 1 second. Yes, I do.
I'm going to take the court to a portion of Mr. Farley's report. And, he gives a detailed background, but I'm going to scroll through to specifically point out the portions of the report that are pertinent to a couple of issues that we're going to talk about, including the soil issue. Now, of course, he talks about his first visit and what he did and how he viewed the facilities on the ranch and developed an understanding of how the cattle calf weaning operation was operated. But a particular importance here is this paragraph, Your Honor, where he talks about this quote unquote, well, two things.
Hold on, your screen did not move.
Okay.
What I am seeing, and I have my notebook that it arrived early this morning. You're welcome to direct me to within the notebook. What I'm seeing on your screen is only the cover page to the combined response.
All right, let me do this because it frankly would be easier, I think, Your Honor, for you to use a notebook. This is Exhibit C to our response.
Hold on, I'm getting there. Oh dear. Okay, Exhibit C. Oh, here we go. I'm sorry, I was looking at tab C. Tab C is case law. Here we go. Exhibit C. All right, I've got it.
So there's a cover page that says Exhibit C. Then there's the first page titled Lee Family Ranches. And then the next page is a page that we're on because we don't have pagination.
All right, so page 2 of that report. All right, yes, sir. You may continue.
So if you count 1, 2, 3, 4, 5 paragraphs down, there's a paragraph that begins, Mr. Addison provided us with the paper. At the end of that sentence, Mr. Farley talks about, he says, quote, the paperwork does describe the soil mixing process and the attempt to reseed the affected area with the native grasses. That quote unquote soil mixing process, that's a reference to the blending work that E-Tech performed on behalf of Memorial, where they mixed the contaminated soil with other soil instead of bringing in clean soil. So he clearly talks about this in his report, but he does it to contextualize what's really important here. And that is, if you skip the next paragraph and we really focus in on the following paragraph, which begins, the Haney test. Quote, the Haney test or soil health test is an integrated approach to soil testing using chemical and biological soil test data. It measures the, quote, living organisms in the soil profile. We use the Haney test to compare the health of the undisturbed soils. So they went outside that 30 to 50 acre footprint where the soil was mixed to look at soil that would have been representative of the property before the breakout at surface. They took the Haney test soil samples outside of the contaminated footprint. They took Haney test soil samples from within the footprint, and then they sent the samples off to a lab to test the level of organic life, either still within or not within the soil. And then if you were to go through the report, which I will not do because I don't think it's particularly a good use of the court's time, what you'll see is they found out that quite literally there are almost no living organisms left in the scalded area, whereas a robust organic environment continues to be in the soils that are outside of the scalded area. So that's important for two things. One, I think it hopefully articulates to the court why Mr. Farley is not criticizing ETEC's work. He's observing what they did, and then he's talking about the implications of what they did. That's the first issue. The second issue, and perhaps it's a good time to transition to some of the points that Mr. Terrell raised. When Mr. Farley says that the ranch is dead, he's not just being colorful. He's referring to these types of tests that show there is a 50-acre patch of dead soil on the ranch. And that ties into broader concerns with respect to the lost utility of the ranch for reasons that I'll talk about now, because it relates to Mr. Terrell's comment that in general, he doesn't think that Mr. Farley should be allowed to talk about the lost utility, the death of the Cedar Mountain Ranch as a cow-calf operation. These next topics relate to Mr. Terrell's suggestion that the Lee Ranch, just as a matter of preference, I think his word was, have decided not to continue using the Cedar Mountain Ranch. And Mr. Terrell's comment that something about the use of ponds and that it's no big deal because there are multiple ponds and cattle, if one pond is contaminated, supposedly should just go to another pond. This relates to all of those issues, Your Honor. And here's the big picture. And I'll direct the court to some exhibits we attached to substantiate this. This is a West Texas cattle ranch. You have to have reliable sources of water to run cattle in general. And in particular, the nature of this cattle operation is not just cows walking around eating, getting fattened up. It is a cow-calf weaning operation. So what's critical here is after mother cows give birth to their calves, the objective is to wean the calves from the mother's milk. The only way that you can do that, Your Honor, is to physically separate the mother cows from the calves at certain strategic points. So the key to the operation, the highest and best use of the Cedar Mountain Ranch, is a setup where you can isolate approximately, I think it was 200, there's testimony, mother calves at a time from their other 200 baby calves, give them a discrete area of the property to both consume wheat and to have access to water. So we now have a 50-acre scalded dead spot in the middle of the area where the calves were being weaned. But the broader import of that, Your Honor, is what that means is it's a commentary on the import of the groundwater at the property. And the lead plaintiff's environmental expert, Mr. Gobb, with respect to the scientific basis for all of this, he has performed soil testing to establish the environmental impacts to the groundwater. And this is Exhibit A, Your Honor, also to our response to the challenge to Mr. Farley?
8.
A, letter A, as an apple.
Thank you.
So first, if I might, Your Honor, ask the court to flip to, it's the third page of the exhibit. It's an email cover page.
All right. Yes, sir.
You see, this is from Mr. Addison to Patrick Gobb. Patrick Gobb, of course, is our environmental expert. Rick is asking, Mr. Addison's asking Mr. Gobb to take a look at some additional information that we received that we believe will be pertinent to the analysis that Mr. Gobb was undertaking with respect to the scope of the environmental impacts and how those environmental impacts created a practical impediment to the operation of the ranch. And so we provide Mr. Gobb this information, and that information is on the next page of the exhibit, or it's actually the page following that. It's titled A&L Plains Agricultural Laboratories, Inc. And
Yellow sheet or the white sheet?
I believe it's the yellow sheet. And at somewhere towards the top, it says critical levels for livestock water. In the left-hand column titled parameters, you can scroll down and you see chloride. It's maybe 5 or 6 entries down.
Yes.
Chloride is the primary constituent, the contaminant in the groundwater at the Cedar Mountain Ranch following the breakout. And if you scroll over to the right, it gives you the critical level and it says 500. That's 500 parts per million, I think milligrams per liter. It's a standard unit of measurement in environmental cases to measure the concentration of a constituent in an environmental medium. So here 500 parts per million is what this agricultural sampling data specific to livestock tells us is the maximum safe level for livestock to consume water with chlorides in it. So what that first means is the notion that there's no quote unquote scientific basis for Mr. Farley's assessment that the impacts at the Cedar Mountain Ranch, the chloride groundwater impacts are too high to raise cattle. This demonstrates that that is simply inaccurate. 500 is the max. Now, if they have not designated a ranching expert, but if some reason they think that they can establish something contrary to what this evidence demonstrates, they're entitled to do that through cross-examination, through their presentation of evidence. But on the basic notion that there's no reliable scientific basis for Mr. Farley to look at the concentrations in the groundwater and draw a conclusion, that's unsupportable. Now, it gets slightly more granular. If we turn to the second page of the actual Exhibit A,
Yes.
there's an embedded photograph with dashed lines on it. They're difficult to read, Your Honor, I recognize, but each of those dashed lines is a contour line to establish the footprint of contamination at certain concentration levels. The widest band is, I believe, 151 or 150, I think 151. There's a second band that is at, I believe that's 250. And these are all different standards that the parties candidly are going to argue about what's the appropriate concentration level to assess the impacts. But the inner band, which is still enormous, is 500 parts per million. And so what Mr. Gobb did is he looked at the different standards that one could use to assess the potential uses of the Cedar Mountain Ranch based upon the contamination. And he included, Mr. Gobb did, because he's our environmental expert, in his analysis, how cattle operations would be limited given the concentration levels of 500 parts per million. Mr. Farley did not do that. Mr. Farley is instead looking at what somebody who is qualified to make determinations about environmental impacts. And I know none of the defendants have moved to challenge Mr. Gobb. So Mr. Farley is, as he's allowed to as an expert, relying upon one of our other qualified experts for the environmental piece, and then drawing conclusions that he's entitled to draw as a ranch management professional. Now, Your Honor, to talk about the practical issue with the ponds, because this too relates to Granfield's position that, oh, this is just about what the leads arbitrarily want to or don't want to do. The key here is that there are two earthen, what sometimes referred to as stock tanks or stock ponds on the property. Those are man-made water bodies. Somebody goes with a backhoe or whatever the heavy equipment is, they dig these things out, they're rainwater fed, sometimes, if you're lucky in West Texas. But the property is so large that you have to have satellite watering locations. These are troughs, metal troughs that sit above ground. And what you do, Your Honor, is you pull groundwater out to fill those troughs. You can't, for instance, use metered water because you would go broke, candidly. You can't pay for this. You have to have some natural water source. Come from the sky or it comes from underneath the ground. So this relates, and I'll just note, I won't go through it, Your Honor, but we've attached deposition testimony from our ranch manager, a gentleman named Roger Graves, as Exhibit D. And all I'll point out here, the defendants deposed Roger Graves on November 28th, 2018. This testimony has been a part of the record for almost 3 years. Detailed descriptions regarding how the lead plaintiff's operation works, how it has to work for it to be an effective cow-calf operation. And that testimony, Your Honor, makes clear there are remote parts of the property away from the scalded area whereby the only water that you can get to those calves, to the cows, is through the groundwater. But if the groundwater is contaminated, and if Memorial through E-Tech to this day has not adequately cleaned up the groundwater and is still migrating, the plume is expanding, you cannot put cattle back on the property, 200 mother cows, 200 baby cows. In Mr. Graves' testimony, he talks about how a single mother cow needs 25 acres. I think we lost.
I think I'm still here. Can you hear me?
I can hear you, Your Honor.
We lose. We lost someone, I think.
It looks like Mr. Terrell.
I can't hear him.
I can see Mr. Terrell. Well, Grady, are you still with us?
Grady, can you hear us?
Right. Let me see. Mr. Ham, if you have the ability to unmute, can you hear us, Mr.
I'll walk down and check on Grady.
All right, thank you, Mr. Right. Carol, Mr. Terrell, can Grady, give me. Right.
Yeah, Grady's frozen. He can't hear, and apparently y'all can't hear him. So I'm going to take him my computer right now.
Right. Thank you.
I may go offline, but I'll boot it right back up.
Can you hear me now? I'm still frozen on there. Maybe. Low system may affect audio.
No, I think I switched speakers here. Hang on. No, I think that's.
On this, I did not go through. Do you know who all the lawyers represent, including the co-counsel who joined in?
Yeah, sure.
Because it's bad.
We take the second one out.
Yes, let's take the other one. Yeah, it's taking it out.
You may want to.
Can you plug that one in?
Oh.
Judge, can you hear me now?
And give me a thumbs up if you can hear me. Excellent. All right, Mr. Knight, you may want to back up a little bit. I'm so sorry. This is the fun of Zoom, isn't it?
Frozen again, I'm sorry.
All right, we have lost. I tell you what, let's, for the sake of this, since you're not the one arguing, why don't we do this, Mr. Terrell? Why don't you just for right now stop the video? And I don't see any video, but I'm going to click stop video. That may reduce your bandwidth. Can you hear us, Mr. Terrell? No, that's not good. All right. Let's do this. I know we've only been at it for about 40. Oh, Mr. Terrell may be back.
I can hear you, Judge, and everybody else, it kind of comes and goes. Can you hear me?
It's very computer garbledy sounding. Let's do this. Let's everyone take a 5-minute break, and perhaps if they log out and log back in, we'll be good. And so I'm going to stand up and stretch my legs for a minute. Y'all feel free to do the same. We'll start back at 9:55.
Trying to find the hearing. The Crystal had it written down somewhere.
The hearing link.
Yeah.
second. I'll just forward it. I'll just forward it to us. Your internet connection. I mean, the internet's not been bad back here typically. Does it?
Never, it's always works good back here. That dedicated deal seems to help it, so should I maybe move to another place?
Where is your, do you know your, did you put this on your calendar by chance? Yeah, here it is. Here it is. Here it is. It says it's got internet.
Can we go into settings and see if it's hooked up to our?
Well, it's connected to Wi-Fi because it's downloading something right here. This is the
Nolan,
Yes.
this is Delenn. I got kicked off for some reason, and did the judge decide to take a break?
Yes, we took, I think it was a 5-minute break to give Grady an opportunity to reconnect.
Okay, thank
Yeah,
you.
we also lost Grady.
Right.
Okay,
And I'm now back. We're trying to let everyone come back. I think we lost you and we lost Mr. Terrell and Mr. Ham. They're trying to reconnect.
Judge, this is Ty. It looks as if the host has stopped our video.
Oh,
So Grady's going to come sit at my desk because I just see if this works.
let me do this. I'm so sorry. I did that trying to maybe help reduce bandwidth. I've
Host, yeah.
now sent you please restart the video.
There's a mouse right there.
Which one?
Any of them. It's mirrored. Well, see, now we got the wrong camera. Hang on, we got the rear facing.
While we do this, let me confirm. We have another attorney. I believe it's an attorney who's logged on. It's Dennis Salater.
Dialati.
And with Rich Hart, he's plaintiff's counsel.
Yes,
Okay, that's what I thought. I saw his. I've seen his name on some emails. So
yes.
Ms. Wilde just wanted to know who to put him down with, and
Thank
then
you.
we
We
have.
should have introduced him. I apologize.
No, it is fine. We just I launched us in this morning. Then we have someone on who is SH. Is that Ms. Oscarson's co-counsel?
That is my paralegal, Sharon Hopkins, Your Honor.
Right, very good. Thank you.
There it goes. There we are.
It's okay. You can be without a coat and tie while you're playing IT.
See if I can hear you now.
All right, Mr. Terrell, are you ready to roll again?
Yes, Your Honor. I thought I'd been sabotaged, IT sabotaged. Now I've got 4 computers and I don't know which one to look at, but I'm ready.
All right, very good. Mr. Knight, we'll go back to you, and I asked Ms. Wilde, you had us the Exhibit D and information from the ranch manager, Mr. Graves.
Excellent. And Your Honor, I'm going to treat that technological glitch as if that was the universe telling me to wrap it up. So I'm going to move this along a lot faster than I perhaps would have. Exhibit D to our response to the challenge to Mr. Farley is the deposition transcript of Roger Graves, who is the longtime ranch manager at the Cedar Mountain Ranch. I'm not going to walk the court through it kind of page by page, line by line. We have highlighted and selected only the pertinent pages, so it's a pretty quick read. But he tells us some things that are essential. He tells us the number of mother calves that on each season would be on the property. It's 200. The calves are with the mothers initially. As I mentioned, the calves have to be then separated because the point is to get them off of the mother's milk, to get them acclimated to consumption of water, to feed them as much as possible, to fatten them up, if you will, so you can send them to market. And the bottom line is, if you do the math, the number of cows, mothers, then calves, the number of acreage, you need a really big property and a lot of space with a lot of cows spread out over that space, but nonetheless separated from one another for this to work. So you cannot operate this property only off of the range-fed ponds. And when if you look at, Your Honor, and we've attached it, well, actually, I'm not sure if it is in the record. The problem when Mr. Terrell questioned Mr. Farley, Mr. Terrell asked Mr. Farley about only the quote unquote ponds, the earthen ponds. He did not in the deposition ask Mr. Farley about the galvanized surface tanks that were fed by water. Now, Mr. Farley tried to explain to him, look, I think there are 2 sources for watering the cows. There are ponds and there are wells. And so if you only look at Mr. Farley's deposition and the reference to ponds as opposed to ponds on one hand and then the galvanized troughs on the other, it gets confusing because it seems like, oh, all the cows everywhere can just drink out of earthen ponds. It is not. Mr. Graves has explained, Mr. Farley understood and tried to explain in his deposition, and he makes reference to it in his report, that the separation of the mother cows from the baby cows and ensuring consistent, dependable water sources for both, which makes the groundwater at the property essential, is the only way that the highest and best use of the property can ever be realized as a cow-calf ranch. Very unique to have these kind of water sources with this quality soil once upon a time at a single property. So when he says dead, that's not hyperbole. He is literally saying the surface impacts and certainly the groundwater impacts are so profound and so expansive that you cannot use this property as a cow-calf operation. And it's just not appealing to anybody to use it for that purpose. So that, Your Honor, I jotted down a couple of quotes that Mr. Terrell made in his presentation. He said, yeah, Mr. Farley speculating about what cows like to drink. He's not. He's relying upon scientific data, the lab reports I mentioned. He's also relying upon his own experience. We detailed this in our response. He teaches at Texas TCU. He has run several enormous ranches, and to this day, he himself runs his own personal cow-calf operation. So he has the knowledge, experience, the training to understand these things and how cows, particularly young calves, react to salty, chloride, contaminated, impacted water. Mr. Terrell made the comment about no testing. There is testing, the Haney test at the soil and the groundwater sampling that Mr. Gobb did with respect to groundwater impacts. Mr. Terrell said there's no scientific reason. The first 2 things cover that observation. Oh, and the final issue, actually, and I'll be quick about this. The blind cows, in Mr. Graves' deposition testimony, again, Exhibit D, he talks about how mysteriously, nothing he or anybody he knows had ever seen in the immediate aftermath of the saltwater breakout at surface, they had approximately 15 calves that went blind. Walking around in circles is the term that Mr. Grave used, which was completely perplexing to them. They found black gunky junk in one of the water wells that they had historically used to water the calves. We are not in this case going to say that, because we don't have to, and this is going to be a takeaway point, that the cattle went blind because of the water impacts. The point that Mr. Farley is making is that as a reasonably prudent operator of a ranch, it would be, and forgive me for being so forthright, it would be insane to continue to run calves on your property when that is the nature of your operation, when one, you've had pools of toxic water on the surface that have scalded the ground. You have groundwater impacts, and then only after both of those things happen, for the first time in living memory for anyone in this case, you have calves that start going blind. Mr. Farley's point is that, yeah, the only thing that you can do at this point, because it's too risky from a business standpoint and it's too risky from a human health standpoint, is to move your cows and calves to a different location. That's the nature of his opinion, and he's qualified to give that kind of opinion based upon his personal experience, based upon his academic credentials, and based upon his professional credentials. So we respectfully request that the court deny in all respects Granfield's and Ivory's adopted motion to challenge Mr. Farley.
All right, Mr. Terrell, do you want to respond for the defendants?
Your Honor, hopefully very quickly, my objection to Mr. Farley was that he said, quote unquote, when he told me in deposition, the ranch in total is dead. There's no basis for that whatsoever. Now, if he can come up with another opinion, a way to say it, that he wouldn't use the ranch until they can figure all this out. But my objection to his use of the term, the ranch is dead. Now, Mr. Farley also said in his deposition that the scalded area of 30 to 60 acres out of this some 1,600 to 1,900 acres, we haven't figured that out yet, was improving. The microbes had been improving, but it's still scalded. He said there were some other grasses that are growing in that area. He didn't really like the grass, but the fact of the matter, it is improving. He also admitted that he didn't know what the chloride level had to be where it would not be fit for the cattle, but he just said if it's too high in chlorides, they don't like to drink it. That's all, Your Honor.
All right, Ms. Oscarson, anything you'd like to add?
Very briefly, Your Honor, Mr. Farley admitted he's not a veterinarian, and so any testimony that he might give about gunky stuff that came out of a well caused the stumbles or blindness in calves, he's just not qualified to give that opinion.
Okay, all right, Mr. Brill.
Nothing further, Your Honor.
Okay, all right, let me go ahead, because I know y'all need rulings. Let me go ahead and make a couple of the court's rulings on this. First and foremost, I am going to, and I want this to be very clear, I'm not going to allow Mr. Farley to testify that the ranch as a whole is dead. Now, it's simply that phrasing. He can talk about scalding. He can certainly talk about the facts of what will grow, what won't grow, what water is, if groundwater is impacted, but it's simply just that aspect of dead. That's not a scientific term. It's to the court, it seems like it's an inflammatory and somewhat misleading term. His opinion may be that it's no longer usable for a cow-calf operation, but it's certainly usable. There's nothing to say that ranch isn't usable for other purposes. And so that's the concern I've got about dead. So he can't refer to it as dead. I'm not going to allow Mr. Farley to testify as to the causation of the blindness or the death of any of the calves or cattle. Again, that's as to causation. Facts that he observed, that's admissible, but he can't give an opinion as to the basis, more of what a veterinarian or a toxicologist would give as to what caused the blindness or the death of the cattle. As to the issue with E-Tech, he can testify to factually any testing he did, factually what he observed. I'm not hearing from plaintiffs that they're trying to make him into an environmental expert or an expert on environmental remediation. And so he would not be able to testify that something E-Tech did was wrong in the manner in which they did it. But I believe he can factually testify that if evidence comes in of what E-Tech did, he can factually testify, I have that knowledge of what they did, and then this is what I saw. This is what I observed. Those are factual evidence and does not require an expert opinion to give the facts.
Okay.
As far as the cattle not drinking the water, I want to read some of the exhibits a little further. I did not have a chance, obviously, to read plaintiff's response last night, so I want to look at some of those exhibits, and so that one will be under advisement. But I wanted y'all to know on these few issues right away what the rulings were. All right, does everyone?
Your Honor, excuse me, briefly, I wanted to understand a little bit better the cow-calf passage about causation.
Yes.
You know, I think as Mr. Knight mentioned, we're not going to be saying what caused that, but I know Mr. Farley is going to be giving an opinion that if he saw or observed those kind of conditions, he would say you need to get off the ranch. And we view those as two different things. And as I understand the court, the latter is permissible.
Yes, because that is his opinion as a ranch manager. I don't want him stepping into causation that would be more along. I don't think he has the expertise based on what, and I'm not sure anyone's trying to turn him into a veterinary expert or some types of bovine toxicologist.
Thank you. I think we understand where that lies.
Okay. All right. Very good. Now let's next turn to what I was hoping we could then do is go to Mr. Foster's deposition. Now, what I realize, the motion to exclude portions of Mr. Foster, what I realize is we've got this other issue that's come up. What I'd like to do is simply address the motion to strike that was filed by the defendants. And then we'll have to deal, I think we've got two different motions pertaining to Mr. Foster. So let's first take up the motion to strike or limit his testimony, and then we'll deal with what impact anything from Mr. Foster has upon plaintiff's total case or all the issues that Mr. Terrell was wanting to raise earlier. We'll deal with that at a later point. So let's simply just go into the defendant's motion to strike. Mr. Terrell, are you taking the lead on that one as well?
Yes, I am, Your Honor.
All right, you may proceed.
Thank you. Your Honor, Colonel Foster issued a 25-page technical memorandum, and we object to many of his factual inaccuracies and conclusions, many of which he abrogated when I took his deposition. But we, other than now the plaintiffs abandoning the idea that C.C. Forbes participated, we still have numerous opinions and conclusions that we want to strike or limit. And I'll be specific about that. On page 6 of his memorandum, he states that due to the age of the SWD number 5, nearby wells and documented surface expressions of produced water, the failure mode of the SWD5 is not likely caused by an improperly plugged well. Mr. Foster testified that he had no facts, no investigation, no other scalp tickets or well files to base that conclusion on. And when I talked to him about it, I said, wouldn't it be nice for an expert, especially an engineer, to have the well data on nearby wells that had been plugged or abandoned? And he said, yes, that would have been helpful, which seems to contradict his idea that the failure mode in the SWD5 is not likely caused by improper plugging. truth and in fact, he acknowledged that there were plugged wells very recently prior to the breakout in September of 2014. And he also acknowledged that due to the age of this well being 57 years old at the time that it had failed, that it had two casing collapses, if you will, or the cement collapsed, and they had to do squeeze jobs twice during the history of the well. He testified that he did not know what the burst pressure of this casing was or what API pipe this was or was not when it was originally installed in 1957. So he acknowledged to me that over time that casing can corrode due to the environment, due to where this the casing is placed in this well, and that decreases the burst pressure of that casing. So we had a long conversation where he agreed with me that sources other than sources outside the SWD number 5 could result in a mechanical failure. And specifically, he told me that it can come from an improperly plugged well or a well that communicates and then basically fractures down a fracture line to the point of resistance, thereby impacting an adjacent well, even over, I believe we had a discussion over a mile or two away, they can be impacted. So that statement, I believe that under his testimony under oath, he's abrogated that as well, but we would move to strike that testimony anyway. Mr. Foster states on page 9 of his technical memorandum, now this is where we may not have an issue. It says he's talking about the CC Forbes field ticket, and he quotes it that there's a note in the field ticket reports that, quote, came out with 8 joints and put a plug on there, pressured up, held. Then Foster then concludes in his report that this notation of the plug is misrepresenting the actual operation that was conducted. Foster speculates that the field ticket was essentially ignoring the deeper packer at 3727 feet and any testing that is reported in this reference to the space between the double E packer set at 261 feet and the wellhead. Foster further concludes that he does not believe an internal plug was dropped or run into the tubing stream. Now I'll stop right there because I think he agreed when I took his deposition that if and read him Baldassar's testimony that there was not a plug placed in this well. A plug would stop up the whole tubing string and would not be effective. He agreed with me that more than likely that this was referring, as Mr. Baldassar testified, a tapped bull plug, which would be screwed on the top of a joint of casing to test pressure. So he's agreed with us on that. However, he doesn't seem in the plaintiff's recent filing doesn't abrogate the comment that he makes that this field ticket essentially ignores a deeper packer at 3727. So we would object to that in testimony entirety, either because he's testified otherwise under oath or with the recent filing by the plaintiff that they don't believe CC Forbes installed an illegal packer. Now, he further, and this is a problem that we have with his testimony, that he testified that and speculates that the second packer, I assume he means the EE illegal packer, which was running the hole, appeared to mask a failure within the system. There was no failure within the system in December 20th of 2010. And now I believe that with their acknowledgement that CC Forbes didn't put an EE packer in the well, that statement is improper and is mere speculation and is inconsistent now with his new position. Mr. Foster opines on page 9 of his memorandum. We say merely his own speculation and conclusion with an attempt to interpret the third-party field ticket without investigating the source of the information. I think that is what the plaintiff's recent filing is, that they are dropping that particular theory. Your Honor, shifting to another line, then Mr. Foster's memorandum at page 16, he states that the wellbore diagram reports and wellbore history demonstrate discrepancy in packer depth. He said Foster does not indicate whether he investigated the efficacy of the wellbore diagrams or work history, and is simply speculating and his conclusion that an EE packer was running the hole in an operation in December of 2010. I'd say more specifically, the deposition testimony of the case clearly establishes that no one knows who prepared the wellbore history. However, I think Mr. Foster in his deposition agreed with me that those wellbore diagrams were unreliable because they're all dated June of 2011. Even though the changes in the wellbore diagram clearly run all the way through the plugging and abandoning of the well in September of 2014. So any testimony regarding whether or not the wellbore diagram is some evidence of some wrongdoing, at least on the part of Granfield, is either speculation or he has now abrogated that opinion. And Your Honor, that then is one of my problems here as we go forward. If the plaintiffs attempt to introduce a wellbore diagram that says EE packer found, or EE packer in the hole 8 joints down as of December 20th, 2010, that's no longer an expert opinion of the plaintiff. And as a matter of fact, they judicially admitted that CC Forbes did not do that. So any testimony regarding that would be very prejudicial to at least defendant Granfield regarding the efficacy of those wellbore diagrams. Now, Mr. Foster goes on to conclude that this packer, assuming the EE packer was concealing a potential leak path from the produced water being injected at the surface and potentially migrating to shallower zones, which creates a dangerous condition within the system. Although that might be some scientific expression by some engineer of what potentially could happen, this as Mr. Foster now doesn't believe that CC Forbes installed a double E packer on December 20th, 2010. So this is simply speculation of what, as the packer wasn't there then, according to him, that this was concealing a potential leak. He doesn't indicate that there was a leak or how he would conclude there was a leak, especially if the operation was successfully performed by CC Forbes, then presumably the H5 test was not faked, where he also says in his report that this was faked or somehow or another there was some trickery there. I don't know if now the abrogation of that theory regarding CC Forbes, he's not going to testify about that or not. This is where he says the EE packer found after the breakout concealed a potential leak and must then assume that the testimony of CC Forbes that the packer was improperly set and an H5 pressure test was performed when the well passed. Your Honor, and I know we throw a lot of this stuff at you like you've been reviewing everything, but an H5 test is required every 5 years on an injection well, or when there's been an operation that's pulled the tubing or the packer. And so any reference by Mr. Foster that this H5 test was somehow or another faked is improper. It's simply speculation and very prejudicial to the defendants. Now, on page 24 of Foster's memorandum, he states that the operator, this would be Granfield, in 2010 did not act as a reasonable, prudent manner with regards to maintaining wellbore integrity. That is completely inconsistent with the plaintiff's judicial admission now that there is no evidence or reasonable inference that C.C. Forbes in that operation hired by Granfield to install a new Model R Packer did something wrong by placing an illegal second Packer in the well. And therefore there is no, Mr. Foster has no proper opinion or any facts or science to back up that in that operation that Granfield, who hired C.C. Forbes, acted unreasonably to maintain wellbore integrity. It sounds like he's now saying they did maintain wellbore integrity. They did install a Model R and not a double E Packer. Foster shows no support for his speculation and conclusion. And now he believes the C.C. Forbes scout ticket or invoice that it was not installing an EE Packer. Your Honor, then Foster goes on to state that the operator of record in 2010, that would be Granfield, appeared to have intentionally filed misleading or false reports with regard to the wellbore configuration and wellbore integrity as required by Texas code. It also appears that the operator directed activities in 2010 by some service companies and some unknown parties in order to create records that would help conceal potential wellbore integrity issues. Your Honor, these statements are inconsistent with the change in Colonel Foster's testimony. There is no evidence and there is no scientific evidence or factual evidence that the operator in 2010, which would be Granfield, intentionally filed misleading or false reports. That kind of statement is not expert opinion. It's simply argument and is highly prejudicial and inconsistent, quite frankly, with now Mr. Foster's testimony regarding the validity of the C.C. Forbes operation. So, Your Honor, I am unclear at this point what Colonel Foster may or may not testify to regarding these topics that I've gone over. But I do find this terribly problematic based upon their admission now that C.C. Forbes didn't install a double E Packer, and therefore the operator being Granfield, who hired C.C. Forbes, there's no evidence that in the dead of night that there was another workover rig put over the hole and an EE Packer was installed. And what would be the reason? That would make no sense whatsoever. So I don't know how Granfield can properly handle this. We have filed and asked the court to reconsider the summary judgment as to Granfield by the logical implication that if C.C. Forbes properly did what Granfield instructed them, then Granfield is not responsible for a double E Packer or any kind of mechanical integrity or false reporting to the Railroad Commission, as there is no evidence that anything else occurred. But back just to the point, and those are my points on the motion to strike Colonel Foster. Thank you.
All right, thank you. All right, let me do this because I obviously, and I understand the plaintiffs are sensitive to needing an opportunity to respond, and I get that. What I am trying to figure out is, because I've had all this volume of paperwork, all right, someone point me, Mr. Knight, can you point me to, I'm hearing comments about judicial admissions. Where do I go to find anything of where the plaintiffs have now said and it may have been in the motions for summary judgment, where I find that the plaintiffs have changed their position as to the double E-Packer being installed.
Your Honor, I can point you right to it. It was a document filed either yesterday or the day before by the plaintiff's style. Plaintiffs supplement to motion to exclude opinions, testimony, and expert. I'm sorry. Yeah, of Andy Burleson, I think is what it's attached to.
And Your Honor, if I may, and I appreciate the way that the court asked the question, because there's a confusion that is being courted by Granfield. The lead plaintiffs have not changed their position that a double E-Packer illegally was installed at 260 feet. That is Mr. Terrell's and Granfield's self-serving editorialization. What we have said is we have exhaustively explored whether or not the service company who illegally installed that double E-Packer at 260 feet was CC Ford's. Now, I'm sure the court remembers, because we've talked about this ad nauseum. There is no question that a double E-Packer was installed at 261 feet below ground on the SWD-5. Because after the well blew out in September 2014, workover rigs went out to the well, physically pulled the well, and found a double E-Packer at 260 feet on the well. We have photographs of it. We have Texas Railroad Commission investigative reports documenting the presence of it. We have, and they're attached as exhibit to our response in opposition to the motion to strike. We have daily workover real-time reports documenting the presence of the Packer at 260 feet. Nothing about that part of the case has at all changed. And in a moment here, I'm going to point you to where Granfield's own expert, Jeffrey Hughes, has opined that a shallow Packer at 261 feet was obscuring the ability to detect defects in the well beneath 260 feet. And because that illegally installed Packer, Jeffrey Hughes, not Mr. Foster, not lay witnesses, their expert, because that illegal Packer was obstructing the ability to detect defects below 260 feet, the well failed. And that was the only source. And I'm getting a little bit ahead here. Mr. Terrell talked about alternative source, plugged and abandoned wells over here. Their own expert has said that's nonsense. Here's what happened. And there's plenty of reason to think that's what happened. There's direct evidence demonstrating what happened. You look at corroded piping in the well. You look at the double E-Packer. You look at where the water was surfacing, was breaking out at surface. That's what everybody relied upon to conclude what happened here, not some speculative theory about what could have happened, but the whole point is there's no evidence. But I digress. I want to make sure I'm addressing this point. We have not changed our theory as to why the failure of the well could not be detected, as to why the conditions deteriorated to the point that we have geysers breaking out at surface with toxic fluid spewing out on our property. The only issue that we have said is after exhausting whether or not CC Forbes installed it, there's no evidentiary basis to conclude that now. But the problem with Granfield's argument is they're not going to be able to put into the evidence that the only person in the state of Texas who can install a shallow double E-Packer is CC Forbes. Just because CC Forbes didn't do it doesn't mean that there's not going to be evidence that a jury will find compelling that it happened on Granfield's watch. And that's the difference.
Oh, all right. So it's a question of, from the plaintiff's standpoint, it's a question of, for lack of a better way to put it, who done it?
Exactly.
All right. I've a lot of this, y'all have obviously probably spent most of the night reading all this, and I wasn't completely up to speed on what our new issue was. Okay, very good. And obviously, I know we'll need to come back, give the plaintiffs an opportunity to review the motion that was filed by Granfield and the motion that was recently filed by Granfield, and to take that up. So, all right, let's go back then to, thank you for getting me on the same page as everyone. Let's go back to Foster's, the motion to exclude Foster. And let me ask Mr. Brill, did you have anything that you wanted to add in connection with Foster, Mr. Brill?
I do not, Your Honor.
All right, and Ms. Oscar,
Judge, this is Bob Brown, just one brief thing. And I'm not saying this has happened, but if it does happen, if plaintiffs' experts who had been critical of CC Forbes prior to the settlement and testified under oath that they were critical of them prior to the settlement come into the court and are now not critical of them, we need to be able to cross-examine those folks on why they changed their opinions, perhaps up to and including the fact that there's no longer any claims, but there used to be against CC Forbes.
I understand that, and we're not taking that issue up at this moment.
I understand. Just wanted to.
Trying to kind of just eat this elephant one bite at a time, as the saying would go. And so what I'm wanting to address right now is the original motion, which was filed by Granfeld a week or so ago, more than a week ago. Let me see, the certificate of service is dated the 27th of August. So that's the motion that that we're addressing right now. But I needed someone, I was hearing so many new things that I needed someone to tell me what in the world is going on. So, all right, Mr. Brill, you don't have anything to address in connection with the motion, the originally filed motion to exclude is what I hear from you, correct?
Correct.
All right. Ms. Oscarson, I may have already asked you, did you have anything that you would like to add in connection with the original motion to exclude?
The only thing is I would like to, Mr. Terrell said this, but underline it because I agree with Mr. Terrell. The plaintiff's position is remarkably different. You could ask my daughter's orthodontist yesterday when I was reading it, and the gasp that I made at 8 o'clock in the morning reading this new thing. The theory is totally different. And so we may need to redepose Mr. Foster and find out what exactly is your opinion now. Because it's not the same. I mean, Mr. Terrell cross-examined him and he conceded a bunch of points, but even still, what is your theory of liability at this point? Because I don't know.
Okay. All right. Mr. Knight, are you taking up Mr. Foster?
I am, Your Honor.
You may proceed.
Your Honor, I'll just note because it may be helpful. I think when somebody carefully reads Mr. Foster's deposition, they're going to find he was not critical of CC Forbes before anything. The point of Jeffrey Hughes, their expert, was to say, yeah, there's no question the Packer was installed. There's no question these sequence of operators, Jeffrey Hughes, not Mr. Foster. Jeffrey Hughes said, yeah, no question it's installed. No question these operators were responsible and should have known better, but I don't think CC Forbes did it. What has happened here is Mr. Foster looked at the evidence as it evolved and testified under oath, honestly, okay, here's what happened. So we have the plaintiff expert and the defense expert who are completely aligned in the theory of what happened. So this notion that the theory of the case has changed, the theories of the case have aligned with the plaintiff's expert and the defense expert on what happened here. But, we will come back to that, Your Honor, but I just don't want to leave some of these statements floating out there to suggest that we've been dishonest or playing fast and loose when all of this stuff is verifiable of record. Now, with respect to the alternative causation issue, that's the first point that in essence, Mr. Terrell was advocating. And I alluded to it. He is suggesting because people looked at the evidence of what is here, his expert, our expert, and drew a conclusion based upon what the evidence actually shows that is somehow defective based upon the fact that there's no evidence to explain some kind of alternative theory. That's not a basis to strike an expert. We included in our briefing a reference to the case Ford Motor Company versus, I think you called it Leela Sema, which stands for the proposition, look, if you want to make these jury arguments, if you want to try to color the facts in the way that you want to color the facts, if you want to cross-examine my witness because you think you can undermine my witness's credibility, our system allows you to do that. But you should not conflate that with the notion, the gatekeeper notion, as to whether or not the expert considered a sufficiently broad range of facts and data to substantiate their conclusion. It should come to no surprise that the plaintiffs and the defendants disagree with the conclusion, though in a moment here is an important caveat. I reiterate, Jeffrey Hughes agrees with what Mr. Foster has concluded on causation. But in the normal case, when you have one side looking at a set of facts and says, here's what we think happened, and you have another side look take an impression that that's a reason to strike somebody's expert. That's the reason we have a system, an adversarial system. And so on this notion of alternative theories, Your Honor, we've attached as Exhibit B to our response the deposition of Jeffrey Hughes.
Right.
Granfield's position is a different plugged well may have been leaking. The leakage from that plugged well, however far removed from the SWD5, which is the well at issue here, that the leaking originated from that other well, migrated all the way over to the SWD5, percolated, accumulated at subsurface all this time. Didn't surface at the other well, mind you. Migrated all the way over here, accumulated for all this time, and then for some reason broke out at surface, geysers bubbling up in proximity to the SWD5. And so their theory is, unless you rule out something for which there's no evidence with respect to the other well being the source, we can't have our expert testify directly as to what he thinks the evidence bears out. The problem with that, and this is why I want to bring the court's attention to what Jeffrey Hughes says. Mr. Addison opposed him and asked Mr. Hughes to explain to us how that occurs, please. And he's talking about the effect of the EE Packer. And Mr. Hughes explains, well, the EE Packer has two cups. You can run both down, you can run both up, and basically you can run one in one direction and one in the other. But as long as one of us down, I believe, I'm just paraphrasing, I don't want to read the whole thing. What that does is it obscures your ability to detect defects in the well below that threshold. That's Mr. Hughes' opinion. And then he goes on to say he believes that one of the cups was in fact run in the direction that caused that to actually happen here. And so in Mr. Hughes' opinion, he thinks that the SWD5 failure was caused by the obstruction of the packer. And on the next page, Your Honor, I mean, he just flat out said, I'm sorry, on page 127 of his deposition, he says, yeah, I mean, just to recap, we talked about the hole in the 2 3/8 tubing on the SWD5. So there's a hole, let me back up, Your Honor. The tubing is the internal piping, the casing is the external piping. You're injecting the salt water down through the internal tubing. You're supposed to have a vacuum between the tubing and the casing, which is called the annulus. And the monitoring is done at surface, among other things, is testing that space between the tubing and the annulus. Should be zero pressure. Because if you have pressure going into that space, what it means is something is intruding into the vacuum. And so that's supposed to tell the operator at surface, okay, your tubing is leaking. But when that packer's up here, it's blocking that annular space. And so when you're running the pressure, it's going and it's bouncing off the packer right here, and you can't get down here. And so what Jeffrey Hughes is saying is because that packer was up here and the tubing had deteriorated, when he says the hole in the 2 3/8 tubing, the water came out of that tubing into the annular space, though nobody could see it. It's corrosive salt water. So it continued to eat on the internal portion of the casing, the outer piping, ate right through it and entered the environment. Jeffrey Hughes is saying this, leading to a hole in the 4.5-inch casing, which would lead to another hole. And then the breakout started somewhere 400 feet underground and then coming to surface. His testimony, not our expert. And our expert obviously agrees. And this is why our theory of the case hasn't changed at all. Now, we've attached also excerpts of Mr. Foster's expert report as Exhibit A. I'm not going to go through it in detail, Your Honor, because I don't think it'd be efficient use of the court's time. I'll just point out to the court that we have cited in our brief, and we have highlighted photographs of the corroded tubing, photographs of the corroded casing. Nobody has offered anything remotely approaching a serious alternative explanation for how the tubing could have been corroded in that way, or the casing could have been corroded in that way if the water was coming from a plug well from wherever. Or one expert, Mr. Burleson, I think Mr. Ash is going to get to this in a moment. I think he's claiming that some literally different geological formation somewhere was the source of the water and is traveling maybe miles. And his theory, Your Honor, is, and it's amazing, he's saying it's traveling miles, that it started to corrode from the outside in and then broke up at the surface, basically at the same time that the external casing gave way. The problem with that is we've got photographs of corroded tubing. Makes no sense, respectfully. So the notion of alternative sources, and what you also see, Your Honor, is our expert in his report, he lists the 4 known sources. There's a figure, and then he narrates it. The 4 known sources of a well failure. So it's not that he, with tunnel vision, chose his outcome and then selected facts to accompany his preferred outcome. That might be a basis to question the soundness of an expert's analysis. He said, here are the 4 known causes for a well failure. Now, let me tell you the one, based upon the evidence, I think is the most probable to have occurred here. Exact same thing that Mr. Hughes said. Granfield and whoever else, if they think that they can take our expert down on cross-examination, good luck, but it's not a basis to strike our expert. With respect to the field ticket, Your Honor, I'm going to be very brief here, but the court may recall that at the outset of this case, there were defendants, including Granfield, who admitted that that field ticket, the CC Forbes field ticket, stood for the proposition that CC Forbes had installed that Packer at 8 joints down. They admitted it. As the case progressed, and we talked to people like Baltazar, Mr. Baltazar, who actually worked for CC Forbes, and another gentleman named Javier Murillo, who actually worked for CC Forbes. And then we progressed to the expert stage, and we started hearing the expert explanations as to what happened here. They came back to the court and they said, oh, you know what, mea culpa. Initially, we thought that the field ticket reflected that CC Forbes was the service company that did it. We want to retract that. All that happened here is Mr. Foster looked at that same evidence and then looked at the evidence provided by the expert, and he did what any responsible expert is supposed to do. He revised his opinion and told them in his deposition his position had changed based upon that evidence. What we say in this response that they're making reference to with respect to the field ticket is completely consistent with what Mr. Foster testified to. The discrepancy issue, and hopefully it's a little bit more clear now, because at one point in time, it sounded, justifiably, the court may have been under the impression that we were saying that there was no shallow Packer at 260, and also that there was no Packer improperly located at approximately 3,700 feet. We have not changed that. And there is no debate that although every single one of these defendants, Your Honor, were filing records with the Texas Railroad Commission saying that the deepest Packer was at approximately 4,700 feet, I believe, that it was actually at 3,700 feet. So they were, in that regard, clearly filing false reports with the Texas Railroad Commission. And, if this sounds really familiar, it's because it seems like barely a week ago, we were arguing the same issue in the context of summary judgment. They haven't done anything to change the record, and nothing that we've said has done anything to one iota alter the record in that regard. So that's the first false statement found in the records that the defendants were filing with the Texas Railroad Commission. But the other issue is, we're not backing off of the fact, and we'll take this up in an appropriate context, because you're right, Your Honor, it is a whodunit. And whodunits are jury questions.
Hold on. My court reporter just said, slow down. So it's fine. It's fine. She's just taking down as fast as she can.
I think I've shifted clearly into my trial mode as opposed to my composed pretrial argumentative mode. I apologize, Your Honor. We've not backed off the notion that Packer was installed in December 2010. And so the other issue here, Your Honor, is that from beginning on December 29th, 2010, the first record filed with the Railroad Commission that inaccurately reported the deepest packer at 4,700 or maybe it's 4,400 feet was filed by Granfield. On December 29th, 2010, the first record that inaccurately suggested there was only one packer on that well was filed by Granfield. And every single operator defendant who's still in this case did the exact same thing. So when we're talking about discrepancies, there is a factual, and it's not even an opinion. It is Mr. Foster looking at documents and saying, yeah, right here it says 4,400 feet, but we know from the defendant's own internal records that it was at 3,700 feet. And we also know from that field ticket, the way that they described what the work that they did. There were approximately 120 strands of tubing in the well. If you do the math, Your Honor, each strand is approximately 31 or so feet. They explained what they pulled out of the well, and based upon the explanation of what they pulled out, that's also consistent with the notion that the packer that should have been at 4,400 feet was shallow of that. So all Mr. Foster's doing, he's looking at documents and saying that these sets of documents say this is what happened, all internal to the defendants, but these records that the defendants were filing with the Texas Railroad Commission are inaccurate. So there's a factual basis for his factual observations with respect to discrepancies. Now, his expert opinion, which he is qualified to give, they've not challenged his qualifications, which he's qualified to give is this type of behavior is absolutely unforgivable. This is a dangerous activity, Your Honor, to inject toxic fluids 4,000 feet beneath the surface. And as a practical matter, having very limited means to know what's happening that deep down. You have to monitor it daily. You have to ensure that the integrity of the subsurface infrastructure is intact. You have to constantly record that stuff. You have to consistently report it to the Texas Railroad Commission. Texas Railroad Commission tells you within 24 hours of seeing some type of deviation on that monitoring, you have to tell us. So Mr. Foster is going to give an opinion by looking at the objectively verifiable facts that this is unforgivable. No reasonably prudent operator would have conducted themselves in the way that these documents objectively demonstrate that the defendants conducted themselves. So this discrepancy and whether or not he can give an opinion, there's no basis to limit his testimony in that regard. I've talked about the shallow packer issue already. Jeffrey Hughes agrees. Your Honor, it was, I believe, Mr. Hughes. I'm just going to bring the court's attention to it in case you care to look at it. We attached Mr. Hughes, a highlighted copy of Mr. Hughes' expert report as a summary judgment response appendix 23. And I'm not going to re-argue it because we frankly should be beyond that at this point. But he's saying the exact same thing. He literally said, yeah, I don't think CC Forbes installed the shallow packer, but the subsequent operators in the sequence of operators before the breakout, they were irresponsible. And here's why. And then he goes on, they also explain, Your Honor, and now he's backed off of that. But again, thank you to Ivory for moving to strike him. He now changes his opinion about Granfield being the one who did it, even though he said, I don't think CC Forbes was a service company that installed it. I still think if you look closely at what he's saying, it happened on Granfield's watch. And then Ivory, as the next operator in line, they had the wellbore diagram. In fact, Mr. Terrell says no one knows who created the wellbore diagram. We have 3 witnesses for Ivory, all of whom have testified under oath Ivory created the wellbore diagram. They testified Ivory got the information from Granfield to input about the EE packer. CC Forbes may not have installed it, but we got bookends, was not there on December 20, 2010. By June 11, 2011, it was there and it was accurately recorded because 3 people at Ivory said, we created the record that documents the presence of that packer exactly where the packer was when we actually when they pulled the well in September 2014.
Your Honor, I'm not going to jump in here, but there's one other element of this that Mr. Knight I know wants to cover. And it's the fact about the 8 joints being pulled out of the well during the rework and then being on the ground. Because it ties Granfield directly to the replacement of those joints at a depth that would take you to the Packer.
And so Mr. Addison's right, Your Honor. We will present argument on that to the jury. And that's a fact issue. Resolve on.
Hold on. Losing you, Mr. Knight.
Are you able to hear me, Your Honor?
You're back. Okay.
I think that I've covered all of the issues. The alternative causation issue, which is kind of the, they're often the absence of evidence, as if it's evidence of absence. I think the expression goes, there's no evidence, credible evidence. And to the extent that Mr. Burleson wants to argue it, and for whatever reason might survive this challenge that Mr. Addison is going to argue, we'll deal with that at that point. But they have no basis to suggest that they can foreclose our expert from giving an opinion on causation that aligns with their expert based upon evidence that's clearly of record. The field ticket issue, it should be a non-issue. The discrepancy issue, I've covered that, Your Honor. The effect of a shallow packer, nobody in this case has disagreed with it, what a shallow packer will do. And so we therefore respectfully request that the court deny Granfield's challenge to Mr. Foster.
All right. Mr. Terrell, let me come back to you. Anything you'd like to add?
Just briefly, Your Honor, I'm not going to respond to Mr. Knight's final argument in this case. Really, the issues are what opinions and conclusions Mr. Foster has that should be allowed or not allowed. Our position is that alternate theories of causation should be explored by each and every expert. And I think Colonel Foster admitted that that was true. And considering other causation of the breakout is something that an expert would like to do. He agreed with that, to eliminate possible causation. That was our entire point. And Colonel Foster, how this all plays, I found the plaintiff's filing and of this issue regarding who installed the double E Packer. And they say, and this is in a plaintiff's supplement to motion to exclude opinions testimony of the defendant's expert, Andy Burleson. And they say in Roman numeral number 1, at the onset of this case, both the lead plaintiffs and certain defendants took the position a field ticket dated December 20th, 2021 reflected CC Forbes installation of an EE Packer on the SWD number 5 during a December 20th, 2021 workover. The lead plaintiffs since have conducted this documentary discovery, fact witness depositions, and most recently expert depositions to test whether there is an evidentiary basis to support the initial assessment that CC Forbes participated in installation of the EE Packer. And they say there is not. Now, all that means to me, Your Honor, as to Granfield, is what testimony Colonel Foster is going to give now different than his report and his deposition testimony of causation relative to Granfield, causation relative to Ivory. And they can talk about Jeffrey Hughes's report, and that'll be at the time of trial, but Jeffrey Hughes says someone installed the Packer after CC Forbes came off the rig. I mean, after that operation on December 21st, 2010. Nobody disputes that. It obviously got in the hole at some point, but the whodunit is based upon plaintiffs now, I think, judicial admission. It certainly wasn't done by CC Forbes or Granfield as of December 21st, 2010. And there is no evidence in this record whatsoever that there was another workover unit or another workover period before Granfield transferred operations to Ivory. There's no evidence. And so as that reflects on a proper opinion of Colonel Foster, we simply don't want Colonel Foster to now come in and say, oh, well, now I conclude that Granfield was involved in some fashion or Ivory was involved in some fashion without proper proof. And since we don't know what his new testimony might be, I don't know how we can prepare for that, the event of testimony by Colonel Foster. That's all I have, Your Honor.
All right. Any other defendant want to chime in on anything? All right, I'll take that as a no. Foster, I'm going to, I want to read his, I've seen multiple times his deposition in its entirety has been attached. I'll read it so I can see what for myself, what he's saying, what he's not saying, and then I'll get y'all a ruling out as quickly as possible. Now, all right, so what we have now is we've got, so that's plaintiff's response. All right, the big binder. We now have plaintiff's motion to limit or exclude certain testimony. Let me ask this. We've now been at it for about another hour. Does anyone need a coffee refill or just to stretch their legs for about 5 minutes? It would not hurt me, I'll put it that way.
Let's do that, Your Honor.
All right, everyone come back and right at 5 minutes. We'll start back at 11:05. Hey guys, I haven't actually managed to step out of my courtroom yet. We had an issue come up court related, so I'm going to be probably another 5 minutes. Thank y'all.
Mr. Knight, Mr. Terrell? Can y'all
Yes,
hear me? This
yes.
is Cindy, sorry. Judge wanted me to let y'all know she's going to be a few minutes longer. Should
Okay,
something come up.
Okay, dope.
Thank you.
no problem. She's got a few other cases to deal with rather than this, I assume.
And Mr. Knight, I'm sorry I interrupted. Got to kind of slow down for me.
Yeah, I have a tendency to, as you can tell, speed the pace of my speech.
That's okay. You're kind of doing work. But we'll be back in a few minutes. Thanks.
First case I ever tried, halfway through a brilliant closing argument, the court reporter said, "I thought you wanted this recorded." And I said, "I do." He said, "Well, you better slow down. I'm just getting about half of it."
Delynn, how's your knee feeling?
Hi, Grady. Doing pretty good. I went yesterday, got a good report. So just having to deal with the more regular problems. Still trying to make sure I don't get an infection, which is part of what, I had going earlier.
Yeah.
So
Yeah, those
Um,
things get out of control. You got a problem.
yeah.
Lynn, does this go
and-
back to your accident of a few years ago?
No, I'm just I wish I could connect that up, Rick. No, I'm kidding. It's just, I'm a heavy person, a woman of substance, been walking around on those knees for a long time. And so I just had to get them replaced, and
Oh, is that what you're going to do?
I've already done it.
Oh, I didn't know that.
Yeah.
Did you do
I
both
had-
of them, Delynn,
Yeah,
or
did you
just
do
one?
both?
I did do both, but not at the same time. I had the first one done in April, and then I just had the second one done in September. So
And-
I've had, and I didn't have any complications at all in April, but I did just recently have a complication that they think is now resolved, but that just, you just don't know what you're going to get. But I'm
A doctor-
trying. The worst part, I don't know if y'all have ever had that done or not, but the worst part is just swelling. So
I had a
terms
Dr.
of trying
Eddie
to,
Glenn that had both of them done at the same time. And he's tough as a boot, but it was pretty painful.
yeah. And the thing, I think the worst part is, our jobs are thinking, and you got to have that medicine to survive that part of that. And you just don't think as clearly as you would like to be. And sometimes you don't recognize it, and that's even worse. So, they want you to stay off work for a specific time period. And I think that's a lot of it is why, because of that pain medication. And then you got to get off of it to make yourself make any sense. I'm not sure I can blame pain medication for not making sense all the time, but
Yeah,
I can sure blame it for a little while.
I fall in that category all the time.
But I will say, I think it's really going to help my mobility, and so I'm real excited about having had it done.
Great. How's rehab gone on the first one?
Good on the first one. It's limited. My rehab was limited on the first one because of the mobility issues I had on the second one. And so I just had that done. So now they're really kicking in the rehab on both of them, trying to really do that. And I'm just going to tell y'all, those PTs, they're not nice.
They're ugly.
They're not nice people. They're not.
We call that
people.
professional detachment. Well,
Did you have that little motorized thing that put on your leg that moved at so many degrees just over and over again?
They did not do that. They got you up. I mean, my brother had both of his replaced before, and they had done that for him, a machine that moved his. But these guys don't use it. They say you got to do it yourself.
All right,
That's interesting.
we got it back. Yeah, very good. Looks like we do. Okay, let's move on to the plaintiff's motion to exclude Keith Wheeler. And whichever one of you guys is going to take that one on, you may have at it.
Thank you, Your Honor. I'll be handling the motions to strike on behalf of the plaintiffs. May it please the court. Before starting the Wheeler analysis directly on his report and motion to strike, there's a introduction that's a part of sort of all of our motions, and I'm briefly going to walk through the standards and the like that we understand apply. At the outset, Your Honor, the decision to, and I know the court knows this, all of this, I'm just mentioning it to make sure I do. But at the outset, of course, the decision to permit or exclude testimony is on the abuse of discretion standard. And the burden of proof is on the party putting forth the expert. And so they have to demonstrate the various aspects of qualifications, reliability, and the like. And I know, as the court also knows, this area is governed basically by the 700 series in the Texas Rules of Evidence. Those rules of evidence are basically identical to the federal rules of evidence. And so there's a body of law on experts, as you would imagine, that runs across the country and basically applies the same words, state and federal. And so you have a number of doctrines that come out of the exact language of the rules that are also threshold decisions that have been determined. And so I'm going to walk through that for a moment. As of course 702 says, that persons can give testimony that may assist or help the jury in areas of scientific and other areas of expertise that the jury would not have knowledge of. And in determining whether or not an individual is able to give expert testimony, there are about 3 or 4 broad standards that are analyzed. The first one is whether they're qualified. And we'll be taking up the qualification issue. What I do want to say is that in the context of these experts, we're going to be talking about some experts who stayed within their qualifications and others who strayed from their qualifications. And the fact that an expert is willing to stray beyond their qualifications is a sign of unreliability, because experts who insist on giving opinions outside their area of expertise and in their area of qualification are seeking to give opinions to the jury that will not assist them and that are inappropriate. And so first you walk through whether or not a witness is qualified. And then secondly, you look to whether or not their testimony and their opinions are reasonable and reliable. And that shakes out, and you go through a variety of doctrines, and reliability, which is the first prong of that, comes up in several circumstances. And I'm just going to talk about two real quickly. One is, of course, the well-known Daubert Robinson in Texas 6 or 7 prong test. And it's the party putting forth the expert's burden to attempt to satisfy that. There's been no satisfaction of that test here. Nothing's been put on by it. I only crossed these experts on one topic of it, whether or not they determine their rate of error, which is an important thing when you're a scientist using mathematical models and the like Mr. Wheeler. And he was unfamiliar with that term and had not calculated his rate of error. When you move beyond the Daubert Robinson standards, Your Honor, you then get into the details of the opinions and whether or not the methodology used was reliable and whether or not the opinions have what's known as reasonable probability or reasonable certainty. And with respect to Mr. Wheeler, our discussion concerning him really goes to his scientific methodology, which we believe is unreliable for a variety of reasons. And so with that in mind, we're going to walk through some of the exhibits and talk a little bit about his report. To start with, I need to mention the status of Mr. Wheeler's opinions. When we took his deposition on September 10th, now almost a month ago, he testified that he did not have final opinions. He testified there were 2 reports he wanted to look at that had come to him recently, which were groundwater monitoring reports. Parenthetically, those 2 groundwater monitoring reports were for 2019, one of them, and it was provided to the Railroad Commission by Memorial Amplify on April 24th of 2020. And what happened in this setting was that we knew there were other groundwater monitoring reports that would be out there because they have to be created on an annual basis. And so we went and got them. We produced the 2 that had occurred since the last ones any of us had seen. And those were produced sometime in the last 2 months because we went and got them out of a Public Information Act request. Those reports in actuality should have been given to Mr. Wheeler long ago because they were put together by Memorial. But he said his opinions weren't final because he had to look at them. Admittedly, Your Honor, he said, I don't think any of my opinions are really going to change. But the point is they're complaining about Mr. Foster. And in fact, Mr. Wheeler's opinions are not final. And his need to not finalize them are based on his desire to look at a document that existed over a year ago, and he should have had. We're going to look at a document he puts together in his report called Figure 4. Part of this case, a whole lot of this case, as you've already heard, involves groundwater contamination. And there are 2 things, several things, but there are 2 things in this case that we're talking about. One is the background level of chlorides in the groundwater. And that's a topic Mr. Wheeler takes up specifically. It is the take-home opinion of his report. Background, Your Honor, is what was out there before the event that occurred that caused the problem. So when we talk about background in soils or background in water, we're talking about what concentrations of those chemicals were out there before the surface breakout, because that has a bearing on how clean you have to clean the site. And Mr. Wheeler's testimony goes directly to that. We disagree with him on that, and we'll be walking through that point. Couple of other initial points before we get to the details. In October of 2014, the Railroad Commission provided a letter to Memorial that is the outline they send when they have a significant spill, surface breakout. And in it are a number of criteria that are to be looked at. And one of those criteria is what's known as the secondary safe drinking water standard. And in Texas, that limit is 300 milligrams per liter, sometimes expressed as 300 parts per million. And just because I'm sure the court doesn't have an environmental case every day, parts per million is usually used when you're talking about solids like soils. The liter analysis, milligrams per liter, is the same concentration, but it's measured in a liquid, hence the liter versus parts per million. So when you hear about soil testimony, it's going to be in parts per million. When you hear about groundwater and surface water testimony, it's going to be in milligrams per liter. And this milligrams per liter background number is really important. Mr. Wheeler is the expert for them on it. And we're just going to discuss how reliable, how qualified, and what the evidence shows with regards to his opinion. We're going to argue in that regard that he has not performed sufficient research. His research is incomplete. And among other reasons, that's one reason why his testimony is unreliable and shouldn't be admitted. Now, on page 7, and I guess the best way to go about this would be to pull up his report, which is Exhibit 2 to our motion to exclude, Your Honor. And what we're going to walk through first is page 7 of Mr. Wheeler's report. And what this goes to, and it's apropos of the arguments we heard this morning, the court will recall there was discussion about 500 parts per million being, or 500 milligrams per liter being used in connection with cattle, and the chloride level they could consume safely in Mr. Farley's and Mr. Gobb's reports. And here at the very bottom, Mr. Wheeler starts in, his opinions are all in the form of questions, which he puts a question out there and then he answers it as his opinion. And here he's talking about, if we look at question 2, what is the appropriate delineation cleanup standard for chlorides in groundwater? And he starts out by talking about Mr. McPherson. And Mr. McPherson is an environmental lawyer out of Dallas who represented the Lees before we were in the case. He's an environmental lawyer who doesn't do litigation. He does cleanups, he does regulatory matters, and he's a knowledgeable person in the area. And apparently, Mr. Wheeler read some information that Mr. McPherson wrote, and he took away from it this next to last bullet point. Well, let's look at the third to last bullet point. The Railroad Commission requires operators to delineate and clean up chlorides to either the Texas secondary maximum contamination level of 300 milligrams per liter or background concentrations, whichever is higher. Well, first off, we totally disagree with that. It's whichever one is lower. And so we disagree with that entirely. Here you're going to see there were numbers of one in the 100s and 200s that ETech and Memorial said would be used as background at this site. Not 300, because it was lower than that when the contamination occurred. That was the background they determined. What we're going to find out is not only did Mr. Wheeler not consider that or use it, but he didn't even address it. With respect to the 300, which is higher than those numbers, he says it's irrelevant. He says background is the number. So let's look at background. We'll come back to 300 and its applicability. Let's look at what Mr. Wheeler does to tell us what we should be cleaning up. So he turns in bullet point 2, Your Honor. And in this sentence, the second, in this bullet point, the second sentence is the important point. And it says, Mr. McPherson further states groundwater should be remediated to levels that are protective of human health and the environment. Then he turns to Mr. Gobb in the next bullet point, and he says, Mr. Gobb's supplemental report, he provides a reference stating that the critical level for chlorides in livestock water is 500 milligrams per liter. And he uses this value to estimate the areal extent of contaminated groundwater. Well, as you'll remember from Mr. Knight's presentation and the map that Mr. Gobb had, he was assigned to look at several different parameters, 300 milligrams per liter, background that he determined. He looked at other staging of the concentrations to determine what should be background. He did not ever propose 500 milligrams per liter, which is for livestock, for the groundwater at the Lee's Ranch, because the Lee's Ranch prior to the surface outbreak had groundwater that was within the national drinking standard. And that's what these well numbers we're going to show you in a moment demonstrates. So here's where we are. First opinion here, he's talking about how clean do we clean this up? He takes Mr. Gobb's number for livestock. He says Mr. McPherson told him, clean it up to the level that it will protect human health and the environment. Let's turn the page. In his next bullet point on what the cleanup level should be, he concludes, based on the landowner's stated cleanup objectives. Well, wait a second. Mr. McPherson supposedly said he wanted it cleaned up to human health standards. Now we're going to hear it's going to be cleaned up to the livestock standard. That is not the human health standard. That is not the standard Mr. McPherson even mentioned if he said any of this. And 500 milligrams per liter will never satisfy it. Mr. Wheeler and his concocted background number, which we're going to disabuse anyone of the notion that it's a scientific opinion, he comes to the conclusion it's 478 milligrams per liter. So even this number that he says is to be used for cleanup, and which he says in the final sentence, attempting to remediate the plume below 500 milligrams per liter serves no purpose, does not satisfy any human health standard. He later testifies, and we'll point it out to you, that the human health standard is irrelevant. Background's the only thing that matters. And in addition to that, there's no evidence really that the Lees ever accepted that to begin with. Now, as we note in our report, Your Honor, on this very topic, he was questioned at his deposition on the issue. And I apologize. So, yeah, I apologize, Your Honor. He then testified at his deposition that 500 milligrams per liter he knew did not satisfy any human health standard, and that it was just not the applicable standard for human health, but that he didn't need to clean up the site to that level because he disagreed with the fact that the Lee's drinking water was below the national secondary drinking water standards to begin with. And so in that regard, Your Honor, I'd like you to turn to Exhibit E to our motion to exclude.
All right, I'm there.
And if you'll tell me when you have that before you.
I've got it.
If you look at that document, Your Honor, and you go down to the third paragraph on the first page, it's part of section 2. And what you'll see is about midway through that paragraph in the middle, it starts with a sentence that says sampling. And there, and this is written by Mr. Nivens. He is he was Memorial's in-house environmental person, I believe, and it's to Fred Holmes. And he's writing him and he says, and this is, I might add, February 16th, 2015, when this is being written, and it describes the initial round of sampling that occurred in the groundwater at the Cedar Mountain Ranch, remembering that the surface breakout occurred back in September of 14. And he writes, sampling of the existing stock wells and domestic wells on site does not show any evidence of hydrocarbon contamination. That's what they found. Chloride levels were also below the secondary MCL in stock well number 1, stock well number 2, and house well number 1. That's drinking water for humans. And then they conclude, at this point, it appears that these wells have not been significantly impacted and are representative of background chloride levels in the area. This is long before Mr. Wheeler makes his presence known on the scene. That was the conclusion of Memorial and their experts, that is background. Mr. Wheeler never considered that as background. There's nowhere in his report where he even recites the levels that were found. Now, it does say at the end of that, stock well number 3 shows a slightly elevated chloride level than the others, 423. Further investigation will be necessary to establish whether this well has been slightly impacted or if it's naturally occurring. That investigation never occurred. No one ever waived off the groundwater limits. And this document also tells us why Mr. Wheeler's opinion that it's the higher of the two is background. If the Lees had water at 100 milligrams per liter chlorides before this, that's background. And they found the levels, whatever you determine background to be, in these 3 wells to be below the drinking water standard. So when they sampled these wells that had not been reached by the contamination, they evidenced that the Lees at their house and in their stock wells had drinking water below the secondary national and Texas drinking water standard. And that is critical. Mr. Wheeler says, no, they didn't. He doesn't tell you why. He doesn't look at all the wells. He just tells you, no, they didn't. That's called Ipsy-Dixit. And Ipsy-Dixit is where an expert just says, believe me, because I say it so. Mr. Wheeler has a lot of those instances. So whatever background number he calculated was not performed using a reliable methodology, because any reliable methodology has to take into account the reality of all the sampling. It has to take into account the reality of the concentrations of the sampling. I might add, he doesn't address Mr. Gobb's background number either. He just concludes his number is 478 milligrams per liter. Now, one other point that is important is that even in the paragraph of Mr. Wheeler's report, where he concludes that the correct standard is 478 milligrams per liter, and that's found, Your Honor, at page 10 of the report. And it's in the summary paragraph where he is summarizing his conclusion on this point. And he uses very carefully crafted wording here. Do you have that page before you, Your Honor? At the very top paragraph, he's giving his conclusion. The maximum chloride concentration in unimpacted well number 13, no evidence to show that was unimpacted. We saw what E-Tech said about the wells and what was background. No one ever determined that well was unimpacted other than Mr. Wheeler. But even then, here's his opinion. Thus, background chloride concentrations can be as high as 478 milligrams per liter at this site. Well, as we note almost ad nauseum in our motion to exclude, Your Honor, part of reliability and one of the overarching doctrines that's used across the country and is covered to the extent necessary in our brief is that your opinion has to be based on probability. It can't be based on possibility. It can't be based on maybe, might, can, could, likely. It has to have reasonable certainty. So even the expression of Mr. Wheeler's opinion doesn't satisfy the rule. And now we're going to walk through why the science doesn't. And if you stay with that report, we're going to turn, Your Honor, over in the back. And I might add, at the bottom of on this page, under question 4 that starts the next portion of it, he refers us to figures 3 and 4 as the evidence of his investigation. And we're going to turn to those now. They are at the back of his report, and you'll see it, the report ends with text. It then goes to tables, and it then goes to these figures. And the third and fourth figures in are the ones that show Mr. Wheeler's incomplete, unsatisfactory, and misleading investigation. And figure 3, if the court, does the court have that yet?
I'm not there yet, I'm sorry.
Okay, no problem. There are about 5 pages of tables.
Okay.
Then you get to some figures. And if you look in the very bottom right-hand corner of each figure, there's a small number. And you'll see number 3 is entitled, is the third one over. It's a map with a square on it, and within it are some lines. That map and square you'll see at the top says see figure 4 for this area. So we're going to turn over and look at the bigger map. And you need to know a little bit about reading these maps, and everybody can correct me if I'm wrong. These lines are called contour lines, and scientists in the environmental area draw these in order to establish where different levels of contamination can be found. And generally speaking, they move outward, and closest to the event, the source, whatever it was, is usually more concentrated. And as you move out, you're less concentrated. Now, let's look at the map, because you can't understand the map without the legend. And the first thing that you see about the legend is that we've got blue lines that are solid. Do you see that one, Your Honor, that says chloride concentrations contour, background? Over in the legend, the blue line says that. And then we've got in the black line, chloride concentration contours at a different level, not background.
Okay.
Now, what we don't have is what the dash line means. And when you look at this map, A ton of it has dashed lines on it. Well, Mr. Wheeler had to admit at his deposition that when you use a dashed contour line, it means you have no evidence. And as you can see, by all of the dashed lines, there are no samples. Mr. Wheeler, as he struggled, he fought not to admit it, but he had to admit that you have to determine the horizontal and vertical extent of contamination, and that every agency he had worked with had done so and requires it. That packet we talked about being sent to Memorial, it says in that packet, you go determine the horizontal and vertical extent of contamination. Here, number one, and this is my first complaint, Mr. Wheeler doesn't even have the dashed line on the legend. That's illegitimate, period. That's not expert. That's not reliable. I let him off the hook and let him say that that was just an oversight, but it's questionable how it could be. The second point goes even further. And we'll talk about it, but the key point there, Your Honor, is that none of this area has been sufficiently represented here to tell us anything. He doesn't know anything where the dashed line is. He doesn't know, in those dashed lines on the westward outward bound area, they start at the very interior line. So there's no evidence of anything beyond those samples that are in the thousands of milligrams per liter beyond that line. Yet he concludes background based on this number at the very bottom that happens to be drawn by a solid line, coincidentally, because there's no evidence to support it. He concludes that's how he gets his number. Now, here's the other important thing. You know how we mentioned the water wells were the ones in that exhibit that showed background below the national drinking water standard? Here, if we go back to our legend, there are three types of symbols that are supposed to be on this map. The first one is the approximate monitoring well locations. Well, he has some of those, but he doesn't use all of them. He doesn't use Mr. Gobbs. He doesn't use every single one to start with. Number two, he's got the approximate recovery well locations. Recovery wells are those red diamonds, and the monitoring wells were the blue diamonds. And recovery wells, Your Honor, are what are being used to pull the contaminated groundwater out in order to supposedly clean it. Here's the take-home point. Look at the third symbol on the map, on the legend. It's supposed to show water wells. Well, if we show the water wells and we show the results from this time period, we're going to have to show a lot of things on there that show milligrams per liter way beyond 478, way below 478, because we know they exist from Exhibit E. For whatever reason, and all you can conclude is that the water wells were once on this map and they were removed, and Mr. Wheeler didn't know to change the legend. So not only does he not describe his inability to assess the contamination through dashed lines, and that's not on this document, but he doesn't even have the water well numbers, which are background. And so he gets to give an opinion. Defendants think he gets to come in here and give an opinion that's background when he misrepresents it on this diagram, and he never considered true background numbers. So yes, we're striking him. Even if he didn't intend to do this, it is so lacking in precision that it doesn't have sufficient reliability to be considered or shown to the jury. Now, just about through with Mr. Wheeler. Oh, one other thing that's really important, and it's important here, and you're going to hear it in Ms. Moore. These people never determined the vertical extent of contamination. They never, you heard the testimony of Mr. Hughes that this might have happened at 400 feet in his expert report. Ms. Moore looked 10 feet deep. The rest of it, she said, nobody looked any deeper for soils that I know of. Mr. Wheeler looked to this first zone and didn't look any deeper. In order to determine the horizontal and vertical extent of contamination, how contaminated the soils are, how contaminated the groundwater is, you have to go look at the locations where the well might have leaked. The well might have leaked at 3736. They couldn't make the packer stick till they pulled out 8 joints. The well might have leaked at 400. It might have leaked anywhere down below all those pictures that show the piping and the casing and the tubing is deteriorated that they pulled out of the well. No one looked there. Mr. Wheeler didn't look there. His report is based on nonsense. And then lastly, his take-home opinion, even the words of it don't satisfy the standard. It doesn't satisfy the probability standard. He doesn't offer any other opinions that are valuable or worthwhile, but he should be struck in his entirety because there's nothing for him to say, but he should certainly be excluded from testifying as to any opinion about what he thinks background concentrations in groundwater for chlorides was, because he didn't do a sufficient investigation. He ignored the existing background standard, and he creates one out of whole cloth that has no support whatsoever. Last point, the defense may bring this up, and 2 points, I apologize. The defense may bring this up, and I guess that would be appropriate, but in no instance does he really get into the exact chloride levels that are on these tables that precede these figures. And I'm not going to walk the court through these, but as the court encounters these types of evidence, I would just mention to you that the way these are presented is you have a well number, you have dates on when these particular monitoring wells and other wells were sampled, and then you start getting results. And as you look through these, you see how contaminated these water wells and monitoring wells were. And then when you get over to the 4th page, they move out of the ones that say MW, Your Honor, and you'll see about halfway down, they talk about water wells. And tell me when you get there.
There.
If you look at those first 4 entries, those were the sampling results that were done prior to that Exhibit E we discussed. And if we go over 6 or 7 columns, you see chlorides in milligrams per liter.
Yes.
Remembering we're in Mr. Wheeler's report. And just below the first water well, the second water well, the sample, you go down some and their wells are gone up because time has gone up. You find there's one at 154. That was the number Mr. Gobb used for the water well. And none of those were used by Mr. Wheeler, even though he had them before him. So you see a lot of experts. I'll also say, if the court wants to go through its deposition, this guy was evasive. He violated Rule 195.3 that says a witness shouldn't be evasive. We had a struggle the whole day we were there, and the defense said I was badgering him, but he wouldn't answer the question. But this witness was evasive. He didn't answer the questions. He wasn't forthcoming. And as we cite in our motion to exclude, Your Honor, there actually is case law that says when a witness is like that and his opinions don't add up, that's grounds to exclude him. So in closing, Your Honor, we would respectfully submit that Mr. Wheeler's opinions are not reliable, are not based on a methodology that's reliable or reasonable, and that they should be excluded.
All right, let me make sure I'm understanding. I'm looking at this table correctly. So what we just looked at, where it has water well number 1,
Yes, ma'am.
because I want to be sure that I'm following what you're saying. There's water well number 1, and then there's a date of January 28th of 2015. And then I come over here to chloride, and it's 118. So that would be 118 parts per liter. Am I understanding that correctly?
Yeah, see, right up there at the top, it says chlorides, and then it has that little Mg/L. And each one of these is being measured in milligrams per liter, except a couple of them, field pH, the first one, and specific conductance, which is over there in a big column. All of these groundwater measurements of concentrations will be in milligrams per liter. So the first measurement in January of 2015 was 116.
Okay.
And then you look at water well number 2, and its first measurement in January was 248. Well, that's below the 300 safe drinking water standard. And so that represents the Lee's unaffected water. Both of those samples were below the safe drinking water standard. You could drink that water. You could tell people we have water that could be drunk by humans. They no longer have that. And Mr. Wheeler concludes cleaning it up to that level has no beneficial effect. Well, it has several, but one of them is it puts the Lees back where they should have been. And number 2, it's safe enough to drink, and that's valuable. And it's valuable in West Texas. And it's indicative of a greater value than a water that has chlorides above the safe drinking water level. So here we have water well 1, water well 2 is below it. You then turn the page, you go to water well 3, and it's above it, and that's the one they said we ought to look at, but nobody ever looked at and determined it was background. You look at water well number 4, it's at 239. You turn the page again, and it doesn't give you the stock well, which was a different measurement that's a part of Exhibit E that was also below the safe drinking water standard. And so those are the quantitative sample results that were out there that Mr. Wheeler includes in his report, and then elects not to even address. So that's how you read that type of a document, Your Honor, and it's never fun because the numbers are always tiny.
Yeah, I understand. Get stronger reading glasses. All right, very good. Let me turn to the defendants. Who's going to take the lead arguing in connection with the defendants?
I will, Your Honor.
All right, Mr. Terrell, you may go ahead.
I bet you're tired of hearing from me, but I have a little bit more. If it pleases the court, you know, the first thing at offset, I was struck by Mr. Addison's argument. We've gotten along famously. I can't say that we haven't, but to say that Mr. Wheeler was evasive is simply not the case. And I'd love for the court to be able to review the video deposition of Mr. Wheeler and the contentiousness and the disrespect that was shown Mr. Wheeler in those depositions. And Mr. Addison and I had a conversation about it, as we, sometimes do. It's not the best in the world, but to say that Mr. Wheeler was not cooperative or evasive is simply not accurate. I know the court doesn't have time, but that would be instructive to see about the 7-minute soliloquy that we had back and forth, yelling at each other about the fairness of what was going on. That being said, it appears in this, Your Honor, and I'm no hydrologist, but Mr. Wheeler is, and he's a professional engineer. He's certainly qualified as a licensed professional engineer practicing in hydrology in many years. And in fact, more than just that, he is not someone that is not familiar with this area. He is currently a consultant for the Texas Railroad Commission that is now cleaning up and consulting on the cleanup of 3 saltwater disposal spills in Texas. He was involved by the Railroad Commission requesting the proper protocol to be used by operators in Texas, and he provided input that was been shared with every operator in the state of Texas regarding cleanups of chlorides. So he's been doing that all of his professional life, and therefore he does know something about what he's saying here. And the Railroad Commission, Mr. Addison refers to his report as nonsense. Well, that nonsense has been relied upon even to this day by the Texas Railroad Commission. So the argument or the issue, it seems to me in this case, is what was the quality of the Cedar Mountain Ranch before the breakout? What was it? And that, I think, is what the scientists call background. From the evidence in the case, we know that the water quality was not great at the Cedar Mountain Ranch because the foreman of the ranch testified they had to move over to city water because it smelled bad, it tasted bad, and it looked bad. But that's not scientific, that's just aesthetics. Mr. Wheeler says, and it's supported by the Railroad Commission letter from Brent Chambers, Amplify Energy, to the Texas Railroad Commission, and they discuss, and Mr. Wheeler cites, what the Railroad Commission requires on cleanup of these type of sites. And I'm going to quote this, and this comes right out of the letter from Sheila Williams, the technical coordinator at the Railroad Commission. Dissolved phase chloride concentrations are either to be delineated to the Texas secondary drinking water standard of 300 milligrams per liter or background. And then the Railroad Commission, and this is information that was written by, or at least where Mr. Wheeler provided input into what this means. And it says if you're going to use background, or what it was before the spill, there are several ways you can do that. The primary way that the Railroad Commission wants you to do it is to use supporting documentation, including area-specific technical data, analytical data through literature research, site investigation, monitoring wells outside the impacted areas, and here's what is important: site activities and stiff diagram evaluation of site monitoring well groundwater, sample anion cantons ratios. And that is the significant part of Mr. Wheeler's testimony, Your Honor, is that no one else, including Patrick Gobb, the plaintiff's hydrologist, used what the Railroad Commission recommends to determine what background levels were. But scientifically, Mr. Wheeler, using the testing provided from Mr. Gobb, he used that and mathematically calculated the background level. This is just math. It's not cherry picking. It's not plugging numbers. It's what the Railroad Commission says that you have to do. The argument that plaintiffs got into with Mr. Wheeler is that his calculation based upon the Stiff and Piper diagrams is that the background was determined mathematically by these formulas at 478 milligrams per liter. And that's just what the math came up. And attached to Mr. Wheeler's report are all these diagrams regarding each and every test well was out there. So Mr. Wheeler then, using that science as he developed and the Railroad Commission has approved as a scientific methodology to determine background. He didn't make this up, and this isn't some kind of weird science here. This is scientifically and approved by the Railroad Commission. Now, this Mr. Wheeler testifies about that this is defensible, it is repeatable, it meets every aspect of Robinson-Dahlberg regarding the use of stiff and Piper diagrams on anon and cantons, and whether or not, basically, Your Honor, in my limited knowledge of what I think this and the experts say, is they can determine mathematically from the testing of these wells to see what is natural salinity as opposed to produced water. And they can determine then whether or not that water came from an injection well or it came from a formation on the property. So that's what Mr. Wheeler does. Now, the plaintiffs were critical that Mr. Wheeler's opinions as to 500 milligrams per liter standard for cows or drinking, he acknowledged, Mr. Wheeler acknowledged, the standard's not the same for humans. He was simply saying that, and he didn't say it was irrelevant, but he concluded mathematically that cleaning up more than background was not required by the Texas Railroad Commission, because you can't clean up what you started with. He found that based upon the testing of each of these monitoring wells, that background was 478 milligrams per liter, and there was no requirement to clean it up past that. Now, the Wheeler said that secondary drinking water standards are not irrelevant, but if the background levels are higher than the standards, the state of Texas does not require cleanup lower than the secondary standard. That is his opinion, and it's supported by the data through the Texas Railroad Commission. So, in essence, if the Railroad Commission doesn't ask you to do it, then you can't clean up what was already dirty, if that's a fair analogy, on the Cedar Mountain Ranch. Now, with respect to Mr. Wheeler's Robinson-Dahlberg criteria, Wheeler's theories have been tested. The geochemical techniques that he used have been widely accepted in the scientific community and regulatory agencies. And we attached as Exhibit C, it's Bates label PIA TRC 477 through 579, clearly showing that these standards using Piper and stiff diagrams, geochemical testing is certainly appropriate and probably the best way to determine background and cleanup levels. Secondly, Wheeler's testimony and opinions are not speculative. His opinion as to background at 468 milligrams per liter is not subjective, but again, based upon widely acceptable geochemical techniques, methodologies that we've discussed. Has Mr. Wheeler's opinions and theories been subjected to peer review? Yes. There are a number of publications, including those that are cited in Mr. Wheeler's report and what we've cited here, including the Texas Water Development Board has used geochemical techniques, canton-ion ratios in a 1973 study performed in Coke County to distinguish between groundwater that had been impacted from chlorides or from oil field activities. Not only that, his theories have been tested and peer reviewed by the Texas Railroad Commission themselves, as he is approved and gives counsel to them on nearly every, or at least the projects he's working on now. The plaintiffs complain that Wheeler's test theories have not been validated by the relevant scientific community. And again, the Railroad Commission has specifically recommended those techniques and provided those techniques to every operator within the state of Texas. The plaintiffs claim that Wheeler's opinions and conclusions were formulated solely for this litigation, but these procedures, as Mr. Wheeler testified about in giving his resume, that these have been used by Mr. Wheeler on similar sites and have been accepted and approved in closing sites by the Texas Railroad Commission. The plaintiffs claim that Wheeler's opinions fall outside his area of expertise, and his deposition and his report clearly shows that he has worked closely with Railroad Commission staff to get regulatory closure of sites based upon background chloride studies similar to the Cedar Mountain Ranch. His opinions are well within his area of expertise, and the Railroad Commission have relied upon his expertise and continue to do so today. Mr. Wheeler's opinions, based upon the geochemical testing, is that the drinking water at the Cedar Mountain Ranch has not been impacted by the saltwater spill because of background levels that he's previously tested. Mr. Gobb does not use geochemical testing in his opinion, and when I asked him about it, he said he was familiar, but I asked him to explain it to the ladies and gentlemen of the jury, and he could not. So, in our opinion, Your Honor, and I think we've shown to the court that Mr. Wheeler is, in fact, qualified without exception to give the testimony and opinions in this case. Thank you.
Thank you, Mr. Terrell. All right, I don't recall, is there any other defendant that is proffering this witness and wants to respond?
Ivory is, and just briefly, Your Honor, Mr. Addison pointed the court to Exhibit 4 of Mr. Wheeler's report, which was the map, and then Mr. Addison was critical of the legend. I would just like to point out to the court that Mr. Wheeler is very clear whenever he basically zooms in on part of around where the spill was. But if the court will scroll up and you can see where he's taking the sample, where he zoomed in, he does include the water wells in the turquoise. It's just that there are no water wells in this, for lack of a better term, zoomed up period. So Mr. Wheeler wasn't trying to be dishonest or had a faulty legend. It's that these turquoise water wells are not close to where the spill was. And so that's all I have to add about that, Your Honor.
Okay, all right. I'm glad you mentioned that because I had noticed that on figure 3, there were water well locations, but it did not look on figure 3 that there were any water wells located within what is then the close-up area of figure 4. Mr. Addison, do you have—
Briefly, Your Honor, it's irrelevant where the water wells are if they're on the Cedar Mountain Ranch when you're trying to determine water quality. You need to take all of them into account, just as ETEC did when they declared that based on these water wells that are down at the bottom of figure 3, they came in under the safe drinking water standard. As to Mr. Terrell's argument that the scientific evidence satisfies Daubert and Robinson, of course it doesn't. And in fact, we went over that in his deposition. And of course, he didn't even perform these calculations or run these models. Someone else did. He didn't have any explanation for how they were run. The question is not whether in some other case he's done something for somebody, including the Railroad Commission, that is similar. The question is whether the opinions in this case have been subjected to peer review, whether or not they've been tested, whether or not he's expressed them outside of litigation. It's not some global technique only. It has to go to the opinions in this case. And then lastly, he admitted that there was no rate of error calculated with respect to these mathematical calculations. At page 108, we have walked through the various scientific equations that he used. He talks about how he had someone else help him in pages 101 through 107. And then at the start of 108, I said to him, okay, in connection with those calculations, are you familiar with a phrase called rate of error? I'm not familiar with the term rate of error. Well, rate of error is at the take home on any mathematical scientific analysis, because there's always a rate of error associated with the performance of math. And that's why someone has to calculate it. They have to be concerned with it. So no, this does not satisfy Robinson. It's not a testing of his opinions. And then lastly, Your Honor, and I'm not going to address this but once. Yeah, Mr. Wheeler was evasive. Yeah, we didn't get along, and I'll tell you why. I told him, if I ask you a yes, no question, you need to tell me yes, no. And I told him, if you don't, and we fought about it, I told him, if you answer something other than that, I don't have a duty to listen to it. The deposition is supposed to be like court. If a witness is objected to in court as non-responsive, the answer stops. He doesn't get to put 20 times on the deposition record the answer to a mythical question. And so I don't put up with it. And every time he did it, I started out politely, but when it happened over and over, it got contentious. Once again, he has to answer my questions, not his questions. Any answer that is yes, no, and then starts with anything but that, I'm going to stop. And that's exactly what I did. I have no duty to listen to an answer to a question other than mine. And I'm not a lawyer who's going to allow a witness, an expert professional witness, who's already produced the kind of evidence this guy has, to stonewall me by trying to evade me. And to the extent the other parties think something else was going on, I don't want the court to take the time to read it because I'm not going to assert it any longer, but that's what happened. And it's common. You ask these people, these experts, did the sun come up in the east? And they say, let me tell you about my opinion. That's the way it goes. So yeah, was I on my very best behavior at the time that happened over and over? Maybe not quite. Did I harass the witness as the rule says? Were those questions solely for harassment? Not at all. We were trying to get to the truth of a stonewalling expert whose only duty is to get his illegitimate opinion into evidence. And so, yeah, I don't take well to that when he doesn't answer my questions. We'd say once again, Your Honor, there is no evidence of any groundwater background number that's in the 400s. These were all below the safe drinking water level. They want to make a case that says they don't have to fool with that. And that's just not what the evidence says. So Mr. Wheeler should be excluded. Thank you.
Right, thank you. And I will take Wheeler's, the motion regarding Mr. Wheeler under advisement, and I will tell counsel, I understand. I've been in plenty of depositions that turn south for one reason or another. I've been inadvertently hit in the face with a microphone in my very first deposition. I had a microphone thrown at my co-counsel and it hit me in the face. And
well, I want to say also, my relationship, just as Mr. Terrell described his with mine, has been wonderful. And it was nice to have a spat with him because it told me I didn't want to have any more.
All right, very good. Let me ask, the next motion we will move to is Deborah Moore. It is 12:15. My staff at some point will need some sustenance. I don't know about y'all. Would y'all be up for maybe about a 30-minute break? Let all of y'all get, maybe hopefully you've messaged your staff and someone's brought you at least in some crackers and cheese or something, but give y'all a moment to regroup, grab a bite of lunch. Let me do the same for my staff, and then we'll get started back at 12:45. Will that work for everyone?
That works great, Your Honor. Thank you.
Sure, Your Honor.
Lunch is here. Yes. Okay. All right. Very good. Yes, that'll be great. We'll see y'all at 12:45. I am actually going to go ahead and turn off the feed, and so we'll log it back on and start back then.
Okay,
Thank you, Your Honor.
so we can all leave.